critically on whether or not to proceed with the impeachment trial of the Vice President against the backdrop of a recent Supreme Court decision. May you always remind us that public service is a sacred trust, that no one is above the law, and that the majority's final decision is anchored on principles of fairness to create a just society. May our decision be made with calmness and humility. More than this highly divisive issue, may our paths be guided by your light when we discuss important pieces of legislation aimed at uplifting the lives of Filipinos and bringing progress to our nation. In the noise of political conflict, be our peace. Lord, please guide us to a clarity of direction in the face of uncertainty, that honor may guide us, that truth shall prevail, and finally, that our nation may unite. Amen.
Thank you, Senator Estrada. Secretary, will please call the...
Senator Marcoleta, Senator Marcos, Senator Padilla, Senator Pangilinan, Senator Soto, Senator Tulfo Erwin, Senator Tulfo Rafi, Senator Villanueva, Senator Villar Camille, Senator Villar Mark, Senator Zubiri, the Senate President.
With 22 senators present, Chair declares the presence of a quorum. Majority Leader.
Thank you, Mr. President. Mr. President, before we proceed with the reference of business, may I just be allowed to acknowledge some guests from the gallery? Guests of Senator Risa Ontiveros, Justice Conchita Carpio Morales, Commissioner Ed Garcia, Commissioner Christian Monsod, Commissioner Feli Aquino, and Justice Adolf Ascuna. Guests of Senator Marcoleta, Mrs. Edna Marcoleta, Congressman Paulo Henry Marcoleta, Ms. Kathleen Marcoleta, and Commissioner Rowena Guanzon. Guests of this representation, Mr. President, may we acknowledge also Justice Efren de la Cruz, former Congressman Doming Rivera, Attorney Rebecca Chato, and the members of the body of Christ. We welcome all of them in this august chamber.
To the aforementioned guests, welcome to your Senate. Majority Leader.
Mr. President, this juncture, I move that we proceed with the reference of business.
Any objection? Hearing none, motion is approved. Secretary is directed to comply.
Resolution, Senate Joint Resolution Number 1, Joint Resolution upholding fidelity to the 1987 Constitution relative to the duties and responsibilities of the Bicameral Conference Committee with a view to ensuring transparency and accountability in the enactment of laws, introduced by Senator Soto III, Ontiveros, Lacson, Legarda, Zubiri, Pangilinan, and Aquino IV.
The Committee on Rules.
Proposed Senate Resolution 24, urging the proper Senate Committee to conduct an inquiry on the alarming level of credit card indebtedness among Filipinos and to recommend policy measures in line with constitutional principles of social justice and consumer protection to address the rising issue of credit card indebtedness and to promote financial literacy among consumers. Senator Villar C.
To the Committee on Rules.
25, resolution urging the proper Senate Committee to conduct an inquiry on the alarming rise of leptospirosis cases in the Philippines and to strengthen the measures for its effective prevention and control. Senator Villar C.
The Committee on Health and Demography.
26, resolution urging the proper Senate committees to conduct an inquiry on the social, economic, and public health impacts of online gambling operations in the Philippines, especially among the youth and minors, aiming to strengthen the regulations that will protect the youth and minors from exposure to online gambling and holding online platforms, operators, and promoters accountable. Senator Villar C.
The Committee on Games and Amusement and Youth.
27, resolution urging the appropriate Senate committee to conduct an inquiry on the proliferation of online job offer scamming activities with an end in view of strengthening existing laws, rules, and regulations to combat fraudulent and deceptive practices. Senator Villar M.
To the Committees on Science and Technology and Labor and Employment and Human Resources Development.
28, resolution directing the proper Senate committees to conduct an investigation on the utilization of funds allocated for national flood control projects and related programs with the end in view of ensuring transparency, accountability, and the effective implementation of flood management strategies in light of worsening and recurring flooding across the country. Senator Aquino IV.
The Committee on Public Works.
29, expressing the sense of the Senate to urge the Executive Department to appropriate agencies to extend all necessary assistance in facilitating the voluntary return of former President Rodrigo Roa Duterte to the Philippines. Senator Marcoleta.
To the Committee on Rules.
30, resolution strongly condemning the illegal arrest and surrender of former President Rodrigo Roa Duterte to the International Criminal Court. Senator Marcoleta.
To the Committee on Rules.
31, resolution directing the appropriate Senate committee to conduct an investigation in aid of legislation into the reported abuse of flood control programs and related projects with the end in view of adopting a comprehensive and effective approach to address the country's persistent and destructive flooding problem. Senator Tulfo E.
To the Committee on Public Works.
32, resolution congratulating Mark Magnifico Magsayo for his hard-won victory, claiming the World Boxing Council Continental America Super Featherweight title. Senator Ejercito.
To the Committee on Rules.
33, resolution commending and congratulating Yumer Marshall for his recent boxing victory. Senator Ejercito.
To the Committee on Rules.
34, resolution loading the immense contributions of Manny Pacman Pacquiao in the field of professional boxing. Senator Ejercito.
To the Committee on Rules.
35, resolution amending Rule 10, Section 20 of the Rules of the Senate by Senator Soto III, Ontiveros, Lacson, Legarda, and Zubiri.
To the Archives.
36, resolution directing the appropriate Senate committee to conduct an inquiry on the alleged anomalies and corrupt practices by the Bureau of Immigration in the processing of tourist visa extension of foreign nationals. Senator Marcos.
To the Committee on Accountability of Public Officers and Investigations.
37, resolution directing the Committee on Health and Demography to conduct a thorough review and evaluation on the implementation of RA 11223, the Universal Healthcare Act. Senator Ejercito.
To the Committee on Health and Demography.
38, directing the appropriate Senate committee to conduct an inquiry to look into the possible immediate action of the national and local governments to address the climate change crisis with the end in view of developing and implementing comprehensive urban and rural planning reforms. Senator Padilla.
To the Committee on Sustainable Development Goals, Innovation, and Futures Thinking.
39, resolution directing the appropriate Senate committee to conduct an inquiry into the alleged questionable investments of the GSIS. Senator Marcos.
To the Committee on Accountability of Public Officers and Investigations.
40, resolution directing the appropriate Senate committee to conduct an inquiry into the recent trade deal between the Philippines and the United States of America. Senator Marcos.
To the Committees on Ways and Means, Trade, Commerce, and Entrepreneurship.
41, resolution directing the appropriate Senate committee to conduct an inquiry regarding the update on the implementation of RA 10692 or the Philippine Atmospheric Geophysical Astronomical Services Administration Modernization Act of 2015 with the end in view of ensuring that the provisions of the law are satisfied and properly implemented. Senator Padilla.
To the Committee on Science and Technology.
42, directing the appropriate Senate committee to conduct an inquiry on the alarming rise in cases of babies being sold online and to identify and address the systematic gaps in the implementation of relevant laws and offices. Senator Cayetano P.
To the Committee on Women, Children, Family Relations, and Gender Equality.
43, resolution congratulating and commending Alexandra Alex Maniego Ayala for her historic achievements and outstanding contributions to Philippine tennis. Senator Cayetano P.
To the Committee on Rules.
44, resolution affirming the legally binding character of the international climate obligations and urging their effective implementation in light of the 2025 International Court of Justice advisory opinion. Senator Legarda.
To the Committee on Rules.
45, commending and congratulating Alas Pilipinas, the national women's volleyball team, for winning silver medal in the 2025 Asian Volleyball Confederation Women's Nations Cup, marking the country's best finish in the Asian level tournament in 64 years. Senator Estrada.
To the Committee on Rules.
46, commending and congratulating Alexandra Maniego Ayala for her runner-up finish at the 2025 Eastbourne Open and for making history in becoming the first Filipina to reach a Women's Tennis Association final. Senator Estrada.
To the Committee on Rules.
47, commending and congratulating pool player Carlo Biado for winning the 2025 World Pool Championship held from 21-26 to July 25 in Jeddah, Kingdom of Saudi Arabia, becoming the first Filipino to win the prestigious title twice. Senator Estrada.
To the Committee on Rules.
48, commending and congratulating the Strong Growth Philippines basketball team for winning the championship in the 44th William Jones Cup men's tournament held from 12 to 20 July 2025 in New Taipei City, Taiwan. Senator Estrada.
To the Committee on Rules.
49, directing the appropriate Senate committee to conduct an inquiry into the delay and abrupt postponement of the final phase of the commissioning of the MILF forces and weapons. Senator Marcos.
To the Committee on National Defense and Security, Peace, Unification, and Reconciliation.
50, resolution calling for Senate inquiry into the quality, reliability, and accessibility of water services provided in areas covered by joint venture agreements between local water districts and private entities, with the end in view of developing an effective regulatory framework that safeguards consumer welfare and promotes transparency and accountability. Senator Tulfo R.
The Committee on Public Services.
51, resolution directing the Senate Committee on Migrant Workers to conduct an inquiry into the existing policies and regulations of the Department of Migrant Workers pertaining to the deployment of Filipino seafarers in high-risk maritime areas following several attacks on ships in the Red Sea. Senator Tulfo R.
The Committee on Migrant Workers.
52, resolution directing the Senate Committee to conduct an inquiry on the existing requirements and regulations of the Marina pertaining to the conduct of seafarers training and refresher courses with the end in view of adopting alternative methods to ease the burden of seafarers. Senator Tulfo R.
To the Committee on Public Services.
53, resolution directing the appropriate Senate Committee to conduct an inquiry on the exorbitant, unreasonable, and predatory prices for domestic flights with the end in view of reviewing the current rules and regulations related to the rates, charges, and fares of Commercial Airlines, Senator Villar M.
To the Committee on Public Services,
54, resolution directing the appropriate Senate committee to conduct an inquiry into potential irregularities in the management and use of OWA funds with the end view of ensuring accountability and transparency in the use of OFW's hard-earned money. Senator Tulfo R.
to the Committee on Migrant Workers, Majority Floor Leader.
Mr. President, at this juncture, the distinguished gentleman from the great province of Tarlac and Rizal, Senator Rodante Marcoleta, is seeking the floor to deliver his privileged speech. I move that he be recognized, Mr. President.
Senator Marcoleta is recognized to deliver his privileged speech. You may proceed, sir.
Thank you, Mr. President. Mr. President, I rise on a question of privilege. Today, I believe the entire nation awaits the disposition of the matter in regard to the impeachment complaint filed against the Vice President, Sara Duterte. In the light of the recent but unanimous decision of the Supreme Court, Mr. President, this decision was promulgated on July 25, 2025, declaring said complaint to be unconstitutional, void ab initio, violative of due process, and that the Senate in the first place did not acquire jurisdiction over it. Take note, Mr. President, it even said that the decision is immediately executory. But before I continue, Mr. President, let me put on record that the initial proceedings, impeachment proceedings conducted by the Senate in the 19th Congress have never been formally carried over to the Senate of the 28th Congress. I do not know, and I'm not aware, I cannot recall of any action so far taken by this august chamber to the effect that the initial impeachment proceedings, which were deemed to have been terminated at the expiration of the 19th Congress at noon of June 30, 2025, have been miraculously brought to life into the present Congress. That having said, Mr. President, I'd like to continue. Mr. President, the decision of the Supreme Court did not dwell on the intrinsic merits of the impeachment complaint filed against the Vice President. It zeroed in merely on the procedures and the processes taken by the House of Representatives. To repeat, it declared the whole impeachment complaint constituting the Articles of Impeachment to be unconstitutional, violative of due process, void ab initio. Simply because the rules of procedure in impeachment proceedings in the House of Representatives were never followed. And they violated the one-year ban on multiple impeachment complaints as prescribed under Article 11, Section 3, Paragraph 5, which says that no impeachment proceedings shall be initiated against the same official more than twice within a period of 1 year. Napakasimple po ng sinasabi doon, Mr. President. No impeachment proceeding should be initiated against the same person more than twice within a period of 1 year. Ilan po ang impeachment proceedings, impeachment complaints na ipinail ng House of Representatives? 4 po eh. The first one started in December 2. Sumunod po December 4. Meron pang sumunod na December 19 hanggang sa umabot po ng February 5. Yun nga pong ipinangangalandakan na impeachment complaint which was signed by more than one-third of the members of the House of Representatives. Nasunod po ba? Nasunod po ba ang tuntunin ng House of Representatives? Noon pong nag-require ang Supreme Court, Mr. President, tinanong po yung House of Representatives in connection with the two petitions filed by several parties before the Supreme Court. One of the items required by the Supreme Court is for the House to give the status of the first three complaints filed. Ano po ang sagot ng House of Representatives? Yun daw pong unang tatlo, the one filed in December 2, December 4, and December 19, were all archived. Nasaan po sa rules ng House na yun pong mga impeachment complaints na ifa-file ay archive? Wala po. Pwede po bang ipakita yung slide na kung saan ay makikita natin ano po ba ang proseso kapag may nag-file na isang impeachment complaint? Ayan po yung Rule 2. Ang sinasabi po sa Rule 2, Mr. President, hindi sa Rule 3, sa Rule 3. Rule 2, Section 3. A verified complaint for impeachment by a member of the House or by any citizen upon a resolution or endorsement by any member thereof shall be filed with the office of the Secretary General and immediately referred to the Speaker. Bakit hindi po nasunod ang tuntunin na ito, Mr. Speaker? Kailan po ni-refer ng Secretary General sa opisina ng Speaker yung impeachment complaint dated December 2, 2024? Kailan po ni-refer ng Office of the Secretary General yung impeachment complaint na i-file noong December 4? Wala po silang sagot. Kailan po ni-refer ng Office of the Secretary General yung impeachment complaint that was received on December 19? Wala po silang sinasabi. Kung titingnan po natin ang sagot ng Solicitor General in behalf of the House of Representatives, ang sabi po nila, the Secretary General diligently referred simultaneously all the impeachment complaints to the office of the Speaker on February 5, 2025. Immediately po ba yan, Mr. Speaker? December 2, December 4, December 19, at isinama po yung February 5, all of them were simultaneously referred to the office of the Speaker on February 5. 2 buwan po ang kanyang ginugol para lang i-refer sa office of the Speaker. Ano po ang immediate doon? Wala po. Wala po silang sinunod. Wala silang ni-refer at ni-refer nga po delayed. Nung ma-refer po, ang sabi po ng Solicitor General, the 4 impeachment complaints were included in the order of business doon po sa session number 36. You will note, Mr. Speaker, hindi po niya ibinigay bilang annex yung order of business in section number 36. Ang kanya pong ipinakita ay yung journal number 36. Bakit po? Sapagkat hindi totoo na yung 4 na impeachment complaints were included in the order of business. Mr. President, I have a copy of the order of business, session number 36. And I will deposit a copy to the office of the Senate Secretary for everyone to see and examine for themselves kung talagang in-include nila sa order of business. Wala po. Saan po nila in-include? Doon sa journal. Iba po yung journal sa order of business. Alam po niyo kung bakit lang nalagay sa journal, Mr. Speaker? Idinagdag po nila as additional reference of business. That is not the requirement of the Constitution. Pwede po ba nating makita yung slide, ano sinasabi po ng Constitution? A verified complaint for impeachment may be filed by the member of the House, blah, blah, blah. Ang sinasabi po rito, iba yun. Hindi po yun. Sorry po. Nakalagay po, in-include sa 10th session day. Yun po yung section number 36. Hindi po totoo yun. Ilang violations na po? Kanina po, in-archive po yung tatlong violations. Hindi po ni-refer sa Committee on Justice. Pangatlong violation. 6 na po. Ngayon sinasabi po, in-include po sa order of business. Hindi rin po. 3 violations na naman. 9 na po. At sabi po nila, yung session 36 is the 10th session. Hindi po. Bilangin po natin yung December 2. That was the date when the first complaint was filed, endorsed, and received by the Office of the Secretary General. December 2 is session number 26. Mr. President, bilangin po ninyo yung session number 26 up to session 36 na sinasabi ng Solicitor General. Yun po ang 11th session. That was not the 10th session. Ang 11th session is session number 35. Just for the record, Mr. Speaker. So ilang violation na po yan? Balikan po ninyo yung Rule 2 na nandyan po sa slide, Mr. Speaker. Ano po yung mode of initiating impeachment? Ganito po ang sinasabi ng rule of the House of Representatives. Impeachment shall be initiated by the filing and subsequent referral to the Committee of Justice. Ito po yung Sereno versus, Francisco versus House of Representatives. Verified complaint for impeachment filed by any member of the House of Representatives, i-refer po sa Committee on Justice. Verified complaint filed by any citizen upon a resolution endorsement by any member thereof, i-refer po sa Committee on Justice. A verified complaint or resolution impeachment filed by at least 1/3 of all members of the House, i-refer din po sa Committee on Justice. Bakit po ang ginawa nila nung makakuha sila ng higit sa 1/3, dali-dali po nilang tinransmit sa Senate? Ang pagkakakala po nila, Mr. Speaker, sapagkat ang pinagbatayan po nila ay yung Rule 4 na kung saan in Section 14 sinasabi po endorsement of the complaint resolution to the Senate. Ang sinasabi lamang naman po noon, Sir President, ay yung pamamaraan kung paano po i-endorse yung impeachment complaint that was signed by 1/3 or even more members of the House of Representatives. Hindi naman po sinasabi doon na hindi na sa i-refer sa Committee on Justice. Bakit po nakalagay dito sa rule? Kailangan i-refer din siya sa Committee on Justice, but they never did. Mr. Speaker, Mr. President. So ilang violations na po ito? You cannot use Section 14 in isolation of Section 2. Hindi po pwede yun. Binigyan po ba ng discretion, Mr. President? Was the House given the discretion to select, to withhold and select from among the 4 impeachment complaints, which will be the one to be transmitted in the Senate in derogation of the 1-year ban rule? Wala po silang discretion. Kung sila po mismo ay hindi sumusunod sa tuntunin. Bakit po ngayon ay napakarami pong nagsasalita? Na parang akala mo ay ang Supreme Court pa ang nagkasala, ang nagkamali. Samantalang ito po, napakasimple po ng tuntunin, hindi kailanman sinunod. Even the 10th session day na sinasabi nila, 11th session day nung ilagay po nila sa order of business, sabi nila. They never included them in the order of business. Wala po. Nasa akin po yung kopya. Ano ba po ang pagkakamali? Mr. President, ipakita po natin yung last page ng impeachment complaint. Pakita po sa slide. Ayan po, Mr. President. Subscribed and verified before me. Sabi po ng Secretary General. Tambayin kopya ko rin. Subscribed and verified before me on this blank day of February 2025. Wala pa pong date. Ito po ba ang verification, Mr. President? Hindi po. Ang verification po ay nakasaad po sa mismong tuntunin ng House of Representatives. Balikan po natin ang Section 3. Ano po ang sinasabi? Section 3, Paragraph 2. An impeachment complaint is verified by an affidavit that the complainant has read the complaint and that the allegations therein are true and correct of his personal knowledge or based on authentic records. At the very least, yun ang dapat na ilagay po. Nakalagay po ba sa verification dito? Ng Secretary General ng House of Representatives? Wala. Ito po'y parang jurat lang sa isang affidavit. Sinasabi lamang po dito, kilalan niya yung nagsipirma sa isang dokumento. Na ang dokumento ay naglalaman ng 32 pages. This is not the verification required under the rules of impeachment by the House of Representatives. Ang totoo po, kung balikan po natin ang Section 14, nandyan po sa slide. Isinulat na po sa tuntunin kung ano po ang dapat kopyahin nila para magkaroon ng tunay na verification. Hindi pa po nila kinopya. Mr. President, ito po yung contents ng verification na dapat sana yun ang nilagay nila sa complaint. We, sabi po rito, after being sworn in accordance with law, depose and state that we are the complainants in the above entitled complaint or resolution of impeachment, that we have caused the said complaint resolution to be prepared and have read the contents thereof, and that the allegations therein are true of our own knowledge and belief on the basis of our own reading and appreciation of documents and other records pertinent thereto. Kokopyahin na lang, Mr. President. Hindi pa nakopya. Mr. President, alam mo po, nung ako'y grade 4, yung teacher po namin, binigyan po kami ng isang short quiz. I-drawing ninyo kanya yung Bicol region. Siguro po 1963 yun, Mr. President. Yung Masbate, hindi pa kasali sa Bicol region. O hindi, kabisado ko naman po sapagkat mahilig po ako sa social studies, Mr. President. Meron pong dalawang nangungopya sa akin. Yung isa nasa likod, yung nasa kaliwa ko. Yung nasa likod po, nakopya niya pong tunay yung aking drawing. Pinagalitan siya pero ipinasa po sapagkat nakopya niya po yung aking drawing. Yung isa po, nangopya na nga, hindi pa niya nakopya. Ang kinopya po, mas bate. O wala po. Hindi po siya nakapasa. Ano pong ibig ko sabihin dito? Kokopyahin na lang eh. Alam po ninyo sa mga litigation lawyers, practicing lawyers worth their salt. Wala ka lang certification of non-forum shopping, i-dismiss ka ng Supreme Court. Paliwanag po yun. Hindi subscribe yung complaint mo, dismiss ka kagad. Mahigpit po ngayon eh. Ito po, this is an impeachment complaint. You are removing the second highest official of government. Yun lamang pong verification. Sablay na po eh. Ano pong nakalagay dito? Section 3, Paragraph 3. An impeachment complaint required to be verified which contains a verification based on information and belief or upon knowledge or information and belief or lacks proper verification, katulad po nito ngayon, shall be treated as an unsigned impeachment complaint. So pwede pong tratuhin pala ngayon sapagkat wala pong verification. It may be treated as unsigned impeachment complaint. Paano ba yun? Pagkatapos magsasalita po ang napakarami. Alam po ninyo kung, Sir President, kumbaga po sa nagluto ng sinaing, pasensya na po kayo kung kinakailangan ako po'y gagawa ng pagkahalin tulad, ano. Ang impeachment complaint po ay parang sinaing na niluto ng House of Representatives. Hilaw po eh. Hilaw na hilaw. Ano po yung hilaw sa Bicolano, Mr. President? Hilaw din po yata. Sa Bisaya, hilaw din po. Sa Kapampangan, Magadto, Mr. President. Sa Waray po, matagudtod. Sa Ilonggo po, lagdos. Sa Ilocano, marakusol. Sana po tama ang aking pagkaka-pronounce. Ang dami pong nagsasalita, Mr. President. Doon lang po sa House of Representatives, isa pong bagong pasok doon. Ngunit patagal na pong nagserbisyo sa ating bansa. Naging senadora, naging Secretary of Justice, naging chairman ng Human Rights Commission. Alam po ba kung ano sinabi niya sa isang panayam? Ito po, nakuha ko. Harap-harapan na tayong niloloko. Kakaibang korte ito. Sana sa palengke na lang final ang impeachment case. At least doon, may nagtitinda ng totoo. Sana po, magtinda po siya ng matagudtod na kanin dyan sa Samar. Baka may bibili kaya. Pwede kaya siyang pumunta dyan sa Pampanga po para magbenta ng magadto na kanin. Kung may bibili, baka sakali. Pumunta kaya sa Panay para magbenta ng lagdos na kanin. Wala po siguro, Mr. President. Baka ngayon dagan dingding, hindi pa patusin. Huwag pong ganun. Ang dami na pong nagsipagsalita. Samantalang hindi po nila nakita. Ang dami, kayo po nagsimula ng mali. Hindi naman po sinasabi ng Korte Suprema na kailanman ay huwag kayong mag-impeach, huwag na kayong mag-file. Ayusin nyo lang po eh. Yun lamang po ang gustong mangyari dito. Ayusin nyo. You want to impeach the Vice President, do it in the right way. Hindi naman po tinignan ng merito eh. Ang sinasabi yung proseso, hindi po nyo sinunod eh. Sinasabi na nga, walang impeachment complaint bukod sa isa. Laban sa isang opisyal sa loob ng isang akalain mo namang 4 po kagad ang ipinay. Pagkatapos yung 4, i-consider mo na isa. Hindi naman po yata tama yun, Mr. President. Mr. President, gusto ko pong basahin isang parte ng official statement of the Integrated Bar of the Philippines and the Supreme Court's decision in Duterte versus House of Representatives, August 1, 2025. And I quote, "Disagreement with the court's reasoning is neither unwelcome nor unexpected. Dissent is not foreign to a democracy. It is essential to its survival. But to incite public repudiation of its authority, or even just to call for its outright defiance, erodes the very foundation of the legal order. Such actions disturb the equilibrium of powers and imperil the integrity of our democratic institutions, especially when appropriate legal remedies remain available within the framework of our constitutional system. If every adverse ruling becomes an invitation to disobey, the law ceases to be a constraint on power and becomes its casualty. The Constitution does not require agreement. It demands adherence." Ang sinasabi po ng mga ibang kasama natin, magpapile pa naman ng motion for reconsideration. Bakit hindi natin hintayin? As I said, Mr. President, if you are a practicing lawyer worth your salt, you are confronted with the unanimous decision of the Supreme Court. In a firm voice, it says this is unconstitutional, void ab initio, violative of due process, and the Senate never acquired jurisdiction over this. And it is immediately executed. Parang sinasabi niya sa'yo, wala ka ng room mag-file niyan. Is anyone expecting that even one soul of the members of the Supreme Court will reverse himself? We cannot depend our action, Mr. President, on the fortunes of litigation. Naalala ko pa nga po Doon sa kaso ng Francisco versus House of Representatives, the former Chief Justice Renato Puno, in a separate concurring opinion, naalala ko po ang sabi niya, with the possibility of 2 impeachment complaints reaching the Senate, the good Chief Justice said that the Senate, in the exercise of its primary jurisdiction, can decide the question of whether or not the 1-year bar rule has been violated or not. The Senate can even decide if on its face the impeachment complaint has no legal basis. At ang sabi pa po niya doon, Francisco versus House of Representatives, sabi pa niya ron if the Senate finds that the 1-year bar rule is violated or that the impeachment complaint has no legs to stand on, that will be the end of the entire controversy. He was saying that let's give all the remedies available to the House and the Senate because of their primary jurisdiction. But when the case is ripe for judicial determination, it was the view of the former Chief Justice that the Supreme Court at that time, and only at that time, when it can speak with great moral authority in order to compel the loyalty, the respect, and the obedience of our people. Mr. President, when the Supreme Court negates the actions of a co-equal branch of government, it does not assert its superiority. Instead, it upholds the supremacy and the dominance of the fundamental law of the land, the Constitution. And so the Supreme Court has already spoken. The last arbiter of law, it says the complaint is unconstitutional, is void ab initio, is violative of due process. The Senate never acquired jurisdiction over this. It is immediately executory. On that note, Mr. President, I respectfully move that the impeachment complaint be dismissed. I so move, Mr. President.
Majority Floor Leader.
Mr. President, before, Mr. President, we act on the motion of the distinguished gentleman from the great province of Tarlac and Rizal. Mr. President, the motion is not among the privileged motions listed under our Rule 32, Section 90 of our rules. Therefore, Mr. President, it is debatable and may be subject to clarificatory questions. Nonetheless, Mr. President, our movant, Senator Marcoleta, has the floor, and Mr. President, subject to his consent and with his magnanimity, clarificatory questions on the motion may be entertained. In fact, Mr. President, we have some members of the Senate who wanted to interpolate with the permission, Mr. President, of the...
What is the pleasure of Senator Soto, our distinguished Minority Floor Leader?
Thank you, Mr. President. If the distinguished gentleman from Tarlac favor me with a few questions, I will be gladly accepting his favor. And if the Senate President will allow me, after a few questions, I will make my own manifestation to that effect.
The gentleman may proceed. Should Senator Marcoleta so allow it?
Yes, Mr. President.
Thank you, Your Honor. Thank you very much, Mr. President. Thank you. So, listening to the privileged speech of the distinguished gentleman from Tarlac, the basis of your motion to dismiss is the Supreme Court's decision, which is now pending appeal by virtue of the MR, or the motion for reconsideration filed last Monday by the House of Representatives. Is it not, Your Honor?
The question whether is it
Yes, your
subject
basis
to
for
appeal?
your motion to dismiss is based on the Supreme Court decision that the so-called impeachment is unconstitutional, based on their decision.
Yes, Mr. President, Your Honor, that's very, very clear and categorical.
Correct. The Supreme Court decision, Mr. President, although immediately executory, is not yet final. Thus, appealable. Ngayon, naka-apela na. Marami nagtatanong, kung naka-apela na, ba't tayo nagmamadali? Na-dismiss ito sa atin. So may I ask the gentleman, what will happen if we prematurely dismiss the case and the Supreme Court subsequently grants the MR and reverses its own decision?
The question, Mr. President, is speculative.
Yes, yes. May I have a speculative answer, Mr. President?
We cannot speculate. We can only guess, second guess, because on the basis of our experience as a practicing lawyer, Mr. President, ito pong ganitong klaseng desisyon, talaga pong wala na pong kaduda-duda na kahit po mag-file pa tayo ng motion for reconsideration. We are hoping against hope. It is as if we are wishing for the moon. Palagay nyo po, palagay nyo lang po merong isa na nag-reverse. Hindi rin po ma-overturn eh. Kasi po ang kailangan po ninyo ay 8 ang mag-reverse. Sa inaakala po ba ninyo meron kayong makukuhang 8 na pumirma doon sa unanimous decision na babaligtarin po nila yung kanyang sarili. Kaya napakahirap pong mag-speculate, Mr. President.
I will accept the answer of the gentleman, but I have done my research, Mr. President. And to remind everyone, the reversal of the Supreme Court's own decision is not impossible, even in landmark cases. In the case of Labugal, Bilaan Tribal Association Incorporated versus Victor Ramos, GR number 127882, December 1st, 2004, questioning the constitutionality of Republic Act 7942 or the mining law, the Philippine mining law. The Supreme Court granted the MR, reversing and setting aside its earlier ruling. And also, Mr. President, just a few days ago, the Supreme Court reversed its own ruling on the definition of a stockholder. This is the case of Lily Lopez versus Lolito Lopez with GR numbers 25497-957-58. So may kasabihan po tayo, ang tumatakbo ng matulin, kung matinik ay malalim. Kaya dapat siguro pag-isipan muna natin kung tama ba na bago magdesisyon ang Supreme Court, basta ibasura na natin ang kaso na ito.
Unang-una po, Mr. President, gusto kong malaman, yung po bang mga kasong sinabi nyo, unanimous decisions po ba lahat?
I am not sure about that. But one thing I can say is that if there is a mistake, a unanimous decision could become a unanimous mistake.
Wala pa pong nangyaring gano'n, Mr. President. At saka po tayo, pag nananakbo, ako po ay nakasapatos at saka sa kalsada kaya hindi po ako matitinik.
Well, Mr. President, there's always a first time. Regardless of whether it's unanimous or not, unanimous decision does not bar an appeal or a reversal, Mr. President. That is one thing for sure. Now, secondly, where is the ball, Mr. President? Or meaning the impeachment case itself? Is it in the Senate or in the impeachment court? Didn't the impeachment court throw it back, remanded, returned to the House of Representatives? So what are we dismissing in the Senate kung wala sa atin ang kaso? Can we continue hearing the case and dismissing it without the impeachment case in our hands? Can we throw the ball out when the ball is not in our possession? Siguro naman dapat magkaroon tayo ng tinatawag nating sense of proper sequencing of moves. Nasaan po ba yung impeachment case?
Mr. President, kanina po sa aking clarificatory statement, ang sabi ko nga po, yung ginawa pong initial proceedings noong 19th Congress Senate, yun po ay nangyari sa panahon po ng 19th Congress at lahat po yun ay naisantabi lahat sapagkat natapos nga po ang termino ng 19th Congress on June 30, 2024. Kaya po natin sinasabi, Mr. President, na dinidismiss na po natin ngayon sapagkat tayo po ang nasa lugar na sinasabihan ng Korte Suprema nung sabihin niyang ito ay immediately executory. Sino pong mag-i-execute nun? Hindi naman po i-execute yun ng House of Representatives. Maliwanag naman po na tayo lamang ang tinakdaan ng kataas-taasang hukuman na gumawa ng paraan para isantabi na po ang usaping ito sapagkat napagtibay nga nila na ito'y unconstitutional, void ab initio, at wala na po tayong jurisdiction para dito.
Thank you, Mr. President. Your Honor, thank you. But as I said earlier, not because it is immediate and executory does not mean it's not appealable. Now, to continue, Mr. President, I hope you don't mind. I will be posing a question, but then I will be doing a manifestation based on this question that I will be posing. So I'm certain that the gentleman from Canal Rock has read the 97 pages ruling of the Supreme Court to come up with this motion. So the question is, must we agree on the statement of the decision of the Supreme Court on page 3, page 56, as basis that the one-year ban has set in? With that question, allow me to proceed with my manifestation with your permission, Mr. President. For the benefit of our colleagues, my colleagues, the last paragraph of page 3 states that, quote, since the 19th Congress terminated, the 3 impeachment complaints became enacted upon, end of quote. Again, this was reiterated in page 56, second paragraph of Roman numeral 5. It says, quote, the House of Representatives, however, was unable to act on the first 3 impeachment complaints because of the adjournment of the 19th Congress. To continue, for constitutional purposes, the first 3 complaints were effectively dismissed. In both instances, Mr. President, the Supreme Court was referring to the February 5, 2025 adjournment. But they have, erroneously believed that the said adjournment is the same adjournment with the sine die adjournment that ends a Congress. It is not. February 5 did not terminate the 19th Congress as stated in the decision. The sine die adjournment of the 19th Congress was on June 13, 2025, wherein the last session day was last June 11. Mr. President, and for the information of the public, there is a world of difference between adjournment versus adjournment sine die. Sa atin, pag nag-adjourn tayo for the Christmas break, nag-adjourn for the Easter break, nag-adjourn for the election period, nothing dies. Treaties, bills, resolutions, anything filed continues. It is never archived. Well, perhaps the lawyers of the ponentes did not realize that, or they were not familiar with the rules of Congress. As I said, this is a world of difference. Now, this is a transcendental case. Ang laking constitutional issue. Wala man lang oral arguments, or at the very least, a consultation with some members of Congress or members of the bar na nakakaintindi ng rules ng Congress regarding the procedure. In that matter alone, Mr. President, kasabihan ninyo mga lawyer, falsus omnibus, falsus unos, falsus omnibus. Mistake in one, mistake in all. In that manner, they wouldn't have decided based on their unfamiliarity with the legislative process. May mali agad eh. Pati ba legislative rules natin gusto nilang palitan? Ganun ba yun? Maybe not everyone may appreciate the importance of the legislative calendar of Congress. But us, it is a big deal. That's why I'm stressing this point. Concurrent joint resolution pa nga when we approve this calendar, only to be misinterpreted and used erroneously in this case. Nag-adjourn daw yung 19th Congress. Kaya na-archive lahat. Now, may kinopya lang, kopya, mali pa. Sabi nga kanina ng ating distinguished gentleman from Tarlac, hilaw. Hilaw yung complaint. Hilaw din yung decision. In addition to this factual error, Mr. President, it can be seen in the website of the House of Representatives that the 3 impeachment complaints were referred to the Committee on Rules and were consigned to the archives on February 6, not February 5, as claimed in page 78 of the decision. Nag-housekeeping lang ang House, kaya in-archive, hindi to end the Congress. This archiving were not the results of the ending of the 19th Congress, but because of the fact that the 4th complaint were already filed and transmitted to the Senate. Eh dito pa lang, Mr. President, pilit na patunayan na barred ang 4th complaint. Kapag ayaw, may dahilan. Kapag gusto, may paraan. Now, to continue, Mr. President, and this is very much related. The Supreme Court, by the way, if it is wrong, if the complaint done by the House of Representatives was wrong, we cannot correct a wrong with another wrong. The Supreme Court essentially amended the Constitution by removing the 3rd mode of filing of impeachment complaint. This 3rd and speedy mode was enshrined there for a reason. In times that there is an urgent need to impeach a person who is influential and powerful and may use his position to evade the law, the 3rd mode, which is the fastest way, was provided in the Constitution. Why don't you ask the authors of this provision in the Constitution? Constitutionalists or CONCON delegates Munsud, Atscuda, Sarmiento. So, Mr. President, continuing, if the Supreme Court is now changing the meaning of initiating, then at the very least, please apply it prospectively. However, they are applying this new ruling retroactively, which is a violation of the doctrine of operative facts. Kung ganito kanilang kagustuhan, at susundin natin basta-basta, apektado din dito yung nakaraang impeachment, the impeachment proceedings. In the words of retired Supreme Court Senior Justice Antonio Carpio, I quote, "The said Supreme Court decision practically voided the impeachment proceedings against former President Joseph Estrada and former Chief Justice Renato Corona." Pag gusto talaga, may paraan. Pag ayaw, may dahilan. Pero wag naman sana pati sa mga ganitong bagay that will ultimately affect future impeachment and legislative rules and proceedings. Sa atin yun eh. I've read that the basis for the retroactive application of the new definitions because the Senate now has not acquired jurisdiction yet. Mr. President, ano tawag natin doon sa nag-constitute kayo as an impeachment court? Nag-robe pa kayo. You even sent out summons. Ano yun? June 9, the Senate President took his oath. June 10, nag-convene an impeachment court. Niremand to the House of Representatives. Tapos yung issue of the summons to the defense. Ano po tawag doon? Hindi nag-convene? Baka hindi nabalitaan ng Supreme Court na hindi nag-convene. Kaya naisabi nila yan. So, now, just an observation. I will try to shorten this, Mr. President. Just an observation, Mr. President. Well, not only myself, but several lawyers mentioned this to me, including my godson, former Senate President Aquilino Pimentel III. Naguluhan sila sa pagkakasulat ng desisyon. It is incoherent and some parts are off topic, sabi nila. Para bang pinagtagpi-tagpi. Basahin niyo mabuti. Uli, ang daming gagaling ng mga abogado rito. Basahin niyo. It even quoted the entire Article 11 of the Constitution not only once, but twice. It seems there were two ponentes. Parang dalawa author dito. Well, that is there in my observations. Just an observation. So, Mr. President, the personalities in this present impeachment case is of no moment to me. The Vice President is a friend of mine. The former President, President Duterte, has been my friend since 1988. Everybody knows that. What I'm pointing out is the danger of outright dismissing the impeachment proceedings by virtue of a decision that is not yet final and still pending appeal. Justice Leodin himself said, Mr. President, I quote, "The Supreme Court is not perfect. Citizens and academics certainly have the right to call attention to the fallibility of the courts." Tama po yun. There is no perfect institution. Even Supreme Court ka, pwede mag-commit ng grave abuse of discretion or culpable violation of the Constitution. A case decided unanimously does not mean that it is infallible. For all we know, it is a unanimous mistake. That again can be corrected by setting aside and reversing prior pronouncements. Again, they have filed, the HRP has the Office of the Solicitor General has filed the MR last Monday. So, in this regard, we shall wait for the resolution of the MR. Please, let us allow and give chance to the Supreme Court to rectify its decision, which contains clear and blatant errors. For their sake and for the sake of future proceedings, let us not dismiss forthwith. And in that light, considering the motion of the gentleman to motion to dismiss, I move to table the motion to dismiss. A motion to table has a higher precedence than a motion to dismiss. Thank you, Mr. President.
Mr. President, may I have a quick reaction to the manifestation of the gentleman?
The gentleman may do so if he so desires.
Mr. President, in the answer of the Solicitor General in behalf of the House of Representatives, there was already a categorical admission that the three initial complaints prior to the fourth one were dismissed because they were all archived. As I have said, archiving is not part of the rules of impeachment of the House of Representatives, but they just did it. Palusot lamang po yun, Mr. President. Paano mo i-archive nang hindi mo susundin yung tatlong steps na sinasabi ng sarili nilang tuntunin? These are not baby steps. These are constitutional steps. At kanina po ipinakita yung slides na yung inclusion in the 10th session day is constitutional. The referral to an appropriate committee is constitutional. There was no referral to any committee. Ang ginawa po nila, tinransmit nila sa Senate without requiring themselves to observe another provision of their own rules. This is to refer to the Justice Committee, where the Vice President might probably be given at least a modicum of right to defend themselves. That is what we call due process. Wala po eh. Inakala po nila na kapag may 1/3 na or more, ay pwede na nilang huwag gamitin yung Section 2 ng kanilang rules. Hindi po nakalagay yun eh. So hindi na po kailangan na i-distingue pa natin yung adjournment and sine adjournment. Kasi inadmit na rin po na in-archive nila kahit na wala po sa tuntunin. Kanina sa manifestation, tinanong din po. Kung wala tayong jurisdiction, paano yung unang initial proceedings? Pwede po yung initial proceedings ninyo will be considered under the doctrine of operative facts. Hindi pa po na-declare na wala pang jurisdiction ang Senate at that time. Ngayon lang po nangyari. Kaya po yung ginawa ng Senate of the 19th Congress, tama pa rin po eh. Wala pa pong declaration noon. Kaya lang, ang kagaya po ng aking clarification na sinabi, all these initial proceedings conducted in the Senate of the 19th Congress were not officially transmitted to the 20th Congress, where I myself belong, a Congress of different composition. So yun po ngayon, naharap tayo ngayon sa issue na talagang tayo lamang po ang gagawa because there is no other agency of government that will execute that decision of the Supreme Court. Only the Senate. So may I go back to the first question, to the original motion, Mr. President.
Mr. President, if I may.
Majority Floor Leader.
Thank you, Mr. President. With the indulgence of my colleagues, Mr. President, our Senate Minority Leader, Senator Soto, and first movant of the motion, Mr. President, Senator Marcoleta, may I respectfully appeal, Mr. President, of our, and remind, Mr. President, our colleagues of our concurrence during our caucus held last week, that we will debate on this and talk about this and discuss this matter, Mr. President. But if the Minority Leader would continue to insist his motion, Mr. President, we have no other choice but to dispose with the motion of the Minority Leader, considering that it takes precedence Mr. President, with the motion of Senator Marcoleta.
It is the understanding of the chair that during our all-member caucus, which the chair announced in plenary, that it was agreed unanimously by all the members that we will be discussing, debating, and acting on the Supreme Court decision on a date certain. And this was the date certain that was agreed upon in caucus. Maybe hear from the distinguished minority floor leader if there has been a change in that position given on that date when we had an all-member caucus.
Mr. President, as a matter of fact, concur with what you said. But during that time when we discussed it, there was no MR filed. There was no motion for reconsideration filed by the House of Representatives or the Solicitor General. So it becomes a different, it develops into a different scenario now that there is a motion for reconsideration. Because again, my question was not clearly answered when I said, what happens if we move to dismiss as what? As a Senate or as impeachment court? I think that is one of the questions that is going to be posed by another member of the Senate, and we wish that you could recognize them to continue debate on this matter before we decide. But again, my answer is that there was no motion for reconsideration when we agreed to decide on August 6 on the motion to dismiss. That's why my motion is not against the motion to dismiss, Mr. President. It is merely a motion to table the motion to dismiss, which you may be able to take up on the floor even tonight or tomorrow. A motion to table is alive always in parliamentary rules, and you may take it up anytime. Then we can take up the motion to dismiss after that, Mr. President. Thank you.
We note the intent of the distinguished minority floor leader, but the chair would therefore like to make some points known before we act on the motion.
Mr.
What is the
President?
pleasure of the majority
Yes,
floor leader?
Mr. President, upon conferment with the minority leader, Mr. President, he is amenable, Mr. President, for us to continue with the discussions and debate on this particular topic, Mr. President. And so with that, Mr. President, may I move that we recognize the distinguished gentleman from Cavite, Senator Panfilo Ping Lacson, to ask his questions, Mr. President.
Well, first, the chair would like to thank the
Thank you,
magnanimity
Mr. President.
of the distinguished minority floor leader in order for us to be able to continue with the debates. The gentleman from Cavite, Senator Lacson, is recognized for his interjections with leave, of course, of the gentleman who has the floor, Senator Marcoleta. You may proceed, sir, if Senator Marcoleta so desires.
Thank you, Mr. President. This is not an interpellation. Rather, this is a manifestation to be followed by a parliamentary inquiry.
The gentleman may proceed then.
Mr. President, I've been diligently reading and reviewing the rules of the Senate since I've been out of this august chamber for 3 years. Nowhere in our rules can I find a provision on a motion to dismiss, as submitted by the honorable gentleman from Tarlac. Neither is there a supplementary application of the rules of court to offer a space for such motion to dismiss, except perhaps in the committees performing their legislative inquiries in aid of legislation. Obviously, we are now assembled in plenary, not as an impeachment court, but as a legislative body, and I cannot relate to a motion in this plenary to an issue that involves a collective decision that falls solely and exclusively under the jurisdiction and authority of an impeachment court. Having said that, Mr. President, my parliamentary inquiry is addressed, of course, to the Senate President. Mr. President, how do we deal with the pending motion? I refer to the motion to dismiss. Shall we even take it up or deal with it? Kasi wala po sa rules natin Paano wala tayo pong guidelines? Kasi wala po sa rules natin yung motion to dismiss. So anong guidelines ang susundin natin in addressing the motion to dismiss submitted by the Honorable Marcoleta? Assuming arguendo, Mr. President, that the motion is voted upon and adopted by this body, what if, Mr. President, the Supreme Court reverses itself when it rules on the MR filed by the House of Representatives through the Solgen? Shall we also backtrack and reverse ourselves in dismissing the impeachment case? I pose that question, Mr. President. Thank you.
Thank you, Senator Lacson. To respond, we were faced with this question, but the very people asking us to wait right now were the very same people who were telling us before to ignore the pendency of a case in the Supreme Court precisely regarding this impeachment complaint. They were egging the Senate, even if we were on recess, to precisely proceed with the trial in spite and despite the pendency of cases in the Supreme Court. And the chair, with an abundance of caution, same with us good senator right now, decided to afford the Supreme Court time during the recess to decide on the matter. And when they did not, the Senate, in accordance with its duty, convened the impeachment court when we resumed session, given that we cannot conduct impeachment proceedings that have not yet begun yet during the recess. To answer the query with respect to motion to dismiss, this was actually done, although not via a motion to dismiss, but a motion to archive in relation to the impeachment complaints of then President Estrada and Ombudsman Gutierrez. In fact, in the case of Ombudsman Gutierrez, it was our distinguished minority floor leader himself, acting as majority leader, I believe, who moved that the case be archived, given the resignation of then Ombudsman Gutierrez for being moot. In the case of President Estrada, the case was likewise archived for being functus officio, given that EDSA DOS happened and a new president was sworn into office. Your Honor, I believe the chair believes that we will have different interpretations of the effect of the Supreme Court decision. But ultimately, as I discussed with the majority leader earlier, once a decision is made by the Senate and the period to seek a reconsideration of that decision put to a vote has expired, the next logical step would be to archive so that it will be made part of our records. It is the position of the chair, subject to the wisdom of the plenary, Your Honor, that given the Supreme Court decision that the Senate never acquired jurisdiction over it, that the proceedings and the articles of impeachment were null and void ab initio. Indeed, there might not even be anything to dismiss, and the procedure would be more properly to archive, similar to what we have done in the past, so that these proceedings will still be made part of the Senate's records. But we will cross that bridge once we put it to a vote, Mr. President.
I go
Your
back
Honor.
to my previous question, Mr. President. Anong gagawin natin sa motion to dismiss? How do we deal with it?
May
We
I
are in
answer,
plenary
Mr.
as a legislative body. We're not an impeachment court. So yun ang tanong ko po, Mr. President. Yun ang essence ng aking parliamentary inquiry.
The predisposition of the chair is what I stated, but subject, of course, to the wisdom of plenary. Maybe here from Senator Marcoleta, with respect to his ideas, given that he is the proponent
Mr.
of the
President,
motion.
it is true that the motion to dismiss is not part of our rules. But it is part of our rules po yung pagiging suppletory application po ng rules of court. In the rules of court, yung korte po can motu proprio dismiss a case kung wala pong jurisdiction. And considering that the rules of court has become part of our rules, that's why I use the motion to dismiss. Pag wala pong jurisdiction, halimbawa, sa isang korte, collection case po ito, 5,000 pesos po yung pinal niya, dinismiss po ng court kahit hindi pa sumagot yung kalaban, Mr. President, kasi Ang jurisdiction po ng korte hanggang 3,000 lang. Ganun po ibig sabihin nun. Minsan po, hindi po verified yung complaint, dinismiss. Sa motu proprio, talagang dinidismiss. Paano po kaya kung sinabihan pa nga na the Senate didn't acquire jurisdiction over the case? Mas lalo po sigurong dapat nating panindigan na talagang i-dismiss na po natin, Mr. President.
Senator Lacson is recognized.
Again, I refer to our rules, Mr. President. Wala rin po ako makitang supplementary application sa rules of the Senate pagdating sa plenaryo. Pwede pong gamitin ito sa mga committee hearings,
Sa impeachment.
inquiry in aid of legislation. But we are not there. We're here in plenary. Maski po basahin natin na 100 beses ang ating rules of the Senate, wala pong supplementary application sa ating rules. Thank you, Mr. President.
The point of Senator Lacson insofar as that is concerned is well taken. Senator Pangilinan.
Just on the point of
Is recognized.
suppletory, the rules of court being suppletory. Mr. President, the rules that are suppletory presupposes that there are no rules of the Senate or the Senate impeachment court. In other words, in the absence of a standing rule or provision of either our Senate rules or the Senate impeachment court rules, then we refer to the rules of court as suppletory to our rules. But in this case, the Senate impeachment court has a specific rule, resolution number 39. Upon presentation of the articles to the Senate shall specify the date and time for the consideration of such articles. Unless the Senate provides otherwise, it shall continue in session from day to day until final judgment shall be rendered, and so much longer as may in its judgment be necessary. In other words, as an impeachment court, of course, not as a Senate in plenary, but even that is now being debated because this representation believes the sole power to try and decide impeachment cases is the impeachment court and not the Senate in plenary.
Mr. President,
Majority Floor Leader.
Mr. President, next to interpolate, Mr. President, on the list of this representation is the distinguished gentleman from Taguig and Pateros, no other than Senator Alan Peter Cayetano. I move that he be recognized, Mr. President.
If I may, Mr. President, with the indulgence of the good gentleman from Taguig and Pateros, yung akin po ay
the lady may proceed.
susog doon kay Senator Lacson ng mga punto.
But, Your Honor,
It's
the
not an
chair-
interpellation yet, Mr. President. I follow up point to the point of Senator Lacson. If the SP
lady may
and
proceed.
the gentleman. Thank you, Mr. President, and with the indulgence, as I said, of the good gentleman from Taguig and Pateros, nabanggit na rin po, Mr. President, pareho ni na Senator Lacson at Senator Pangilinan, yung usapin ng tayo ba, Senate or Senate impeachment court ba? So this is a point of inquiry, actually, a brief point of inquiry, Mr. President, related to the motions at bar now. The question presented to the body is related to an ongoing impeachment case, which is within the jurisdiction of the impeachment court. Should we not first have the newly elected senators take their oaths as senator judges and convene as an impeachment court? I note, Mr. President, that the Supreme Court decision is not yet final. As colleagues have mentioned, a motion for reconsideration has been filed by the House of Representatives, and the court itself, the Supreme Court, has given 10 days for the Vice President to comment. So yung point of inquiry ko nga po, Mr. President, hindi po ba dapat pasumpain na muna ng presiding officer with us convened as an impeachment court, yung mga bagong halal na senador para makapag-convene po tayo bilang impeachment court at i-treat yung mga motions at bar. Salamat po, Mr. President.
Noted and entered into the records. What is the pleasure of the Honorable
Just a very quick intervention. Very quick, Mr. President. With the
Pangilinan?
permission of
Yes,
our
you may
Mr.
proceed, sir.
Yes, Mr. President, and we place this on record after reading the ruling, the decision of the Supreme Court. Mr. President, the Supreme Court referred to the Senate impeachment court repeatedly. And therefore, it is the Senate impeachment court that was also impleaded. It is the Senate impeachment court that may, if it opts to, file a motion for reconsideration. And therefore, this motion to dismiss, we believe, should be forwarded to or tackled by the Senate as an impeachment court.
Your Honor, just on that point, the parties mentioned in the case is not the Senate impeachment court, but the Senate. And the dispository section of the decision makes mention also of the Senate. If I may quote, consequently, the Senate did not acquire jurisdiction to constitute itself as an impeachment court. That's the decision of the court in Duterte v. HOR.
Mr. President, and we will go back to the earlier manifestations
The
of...
mic, please.
We will go back to the earlier manifestations of the minority leader. Yes, the Supreme Court ruled that we have no jurisdiction. Yet, the decision is flawed in terms of the facts on procedure, the one-year bar, and on due process. This is at least, of course, our assertion. And therefore, should we not wait for a motion for reconsideration to be resolved before we proceed and vote on the matter that has removed from the impeachment court jurisdiction? Should we not at least assert the power and the prerogative under the Constitution of the Senate impeachment court in terms of the exclusive jurisdiction, number one, and the sole power to try and decide?
That is what we will be deciding and voting upon this afternoon, Your Honor.
Thank you, Mr.
Senator
President.
Cayetano is
Yes,
recognized.
please, Mr.
Thank you, Mr. President. The distinguished gentleman, Senator Marcoleta from Tarlac and Senador ng buong bansa. Sir President, initially I wanted to speak pagbotohan na po. But very interesting po yung question na bringing up ni Senator Lacson. But aside from that, Mr. President, masyadong mabigat yung crossroads na hinaharap ng ating bansa. And remember, assuming we do nothing today, I am 101% sure that on February 6, 2026, an impeachment case will be filed against the Vice President. Maybe against other impeachable officers too. So I think it is very important that mahimay natin yung desisyon, yung sentimento ng institusyon na to, mailabas hindi lang sa social media at sa traditional media ang mga puntong nagsasaliwa, meaning pong parang hindi nag-uusap eh. So at least here we disagree, but whether we listen to the minority leader or to Senator Marcoleta, we agree to listen to each other and to examine each other's points. So I just like a few minutes on some very important matters. Let me start by the accusation that because of this decision, masyado nang mahirap at wala nang mai-impeach. So may I ask Senator Marcoleta if he would give me the honor of asking him a few questions and allowing me to interpolate on 2 or 3 topics. The first one is whether or not naging imposible na mag-impeach under this decision.
The gentleman may proceed if Senator Marcoleta will so allow it.
Yes, Mr. President.
Mr. President, sabi po nung iba, imposible na daw mag-impeach ngayon dahil sa desisyon. I
Hindi
see the
po.
decision before you. I approached you last week. You've been studying it. I see your radio program. Mukhang 10 beses mo na nabasa yung desisyon at apparently, Mr. Senator, you also listen to criticism. So kung ano rin yung sinasabi ng iba, pinapakinggan mo rin. In your view, may I take note first, Mr. President, that I am glad that the Senator made a distinction na he is for the rights of everyone. He was adopted by PDP and ran with a particular party, but he is not a member of the Duterte bloc. Am I correct there?
Technically speaking, Mr. President, I am not a member of the PDP, but I admit that I was adopted and I ran in unity with some of the parties of the PDP candidates at the
The
time.
point I'm going at is like, I was a cabinet member in the Duterte administration, but I have not talked to the Vice President. I ran as an independent in 2022, so I speak now as a senator and not as a partisan. I assume the same, Your Honor.
Yes,
that
Mr.
you're
President.
giving your own personal opinion as Senator Marcoleta, not as a partisan. Of course, I assume that for everyone here, no? Regardless of our position. So, Mr. Senator, sa iyong paghimay ng desisyon, sa tingin mo ba imposible na ngayon mag-impeach ng isang impeachable officer?
Hindi po, Mr. President.
So naging napakahirap ba mag-impeach ng isang officer?
Hindi ko po alam kung bakit mahirap po sa kanila, Mr. President. Ang importante lang po, ilagay lang po sa tamang proseso. Napakasimple po kasi nung kanilang mga tuntunin, iniisip ko, sundin lang yung mga tuntunin. Ang problema po, isa man sa tuntunin, wala pong sinunod. Kaya po humirap ng humirap para sa kanila.
So, Mr. President, I'm glad you mentioned tamang proseso. I think the way the Supreme Court said it in page 95 of the decision, there is a right way to do the right thing at the right time. The problem, Mr. President, is sinasabi po nung iba, may decision na sa former decisions, meron ng definition ng initiation, and many of us here were not mere spectators there. I mean, Senator Soto, I think, was in the impeachment court, di ba, of Senator Estrada, Senator Laurentu. Senator Kiko was still on the, we were together kay Senator Corona. Senator Cheese and I and Senator Miggs were in the House during the prayer 1/3 to the Senate Articles of Impeachment, di ba? So, hindi po tayo stranger sa mga pangyayaring ito. Ang punto ko, Mr. President, Senator Marcoleta, kung hindi nagsabi ang Supreme Court ng specific na dapat sundin, pwede kong ma-interpret na baka naman masyadong mahirap. Baka naman kahit anong i-file kung gustong protektahan, hindi na siya ma-impeach. Paano na yung accountability? But is it true, Mr. President, that on page 93 of the decision, the Supreme Court actually narrated what has to be done for a valid impeachment complaint?
Yes, Mr. President.
Allow me to read. 1, the draft article of impeachment or resolution should be accompanied by evidence when made available to members of the House, especially those who are considering its endorsement. 2, the evidence should be sufficient to prove the charges in the articles of impeachment. 3, the draft articles of impeachment and their accompanying evidence should be made available to all members of the House of Representatives, not only to those who are being considered to endorse. Impeachment is an act of the entire House, which requires a qualified minority of only 1/3 of its members to be transmitted to the Senate. However, the House of Representatives is a deliberative assembly where each member should be allowed to represent the views of their constituents. Let me stop there first. Mr. President, may problema ba yung number 1 na yung articles of impeachment kailangan may ebidensya?
Wala pong problema doon, Mr. President.
Hindi ba ho baliktad? Kung walang ebidensya, may problema.
Tama po.
Kasi kung walang ebidensya, ano yon? Tapon mo sa Senate, bahala na si Batman. So, precisely tama ang Supreme Court that even if 1/3 endorse or file, dapat may ebidensya na. Let me go to the second part. The evidence should be sufficient to prove the charges in the article of impeachment. Mr. President, tama po ba na iba po yung sufficiency at iba din po yung quality or yung burden of proof? Di ba?
Opo.
So halimbawa po, sa piskalya, hindi po kailangan sa piskalya beyond reasonable doubt.
Probable.
Kailangan lang that there is probable cause that a crime was committed and there is probable cause that the accused committed that crime.
Yes, Mr. President.
So in the same manner, hindi sinasabi dito sa 2 na kailangan mo ipresenta sa mga congressman lahat ng testimony, lahat ng ebidensya Ang kailangan lang, if you assume the evidence to be true, it will be enough to convict.
Tama po.
Because if not, then sayang lang ang oras natin sa Senate. Kung may articles of impeachment ka, walang ebidensya or may ebidensya pero yung ebidensya is not sufficient to prove the charges, either the Senate will be a kangaroo court and convict without evidence or we will be wasting our time. So wala rin problema sa number 2, Mr. President.
Wala po, Mr. President.
Number 3, ang sinasabi lang ng number 3, kahit na pumirma yung 1/3, kailangan ipakita pa rin sa lahat ng Kongreso. Isa po sa hinanakit po yun nung bata ako dahil ako po'y payat nun at hindi katangkaran. Parati akong saling pusa sa basketball, baseball, volleyball, dahil hindi po ako ganong kagaling sa sports. Sa Congress ba, hindi ba tamang rule to? Na kahit wala ka sa majority, kahit wala ka sa qualified minority, kapag ka may impeachment, merely being elected as a representative of the district or of the party list, dapat ipakita man lang sa'yo yung articles of impeachment at saka yung ebidensya.
Tama po kayo. Wala man lang po akong nakita sapagkat ako po hindi isinali sa pakakitaan ng...
So naiintindihan niyo po kung paano maging saling
Hindi ko nga
pusa.
po alam na meron na po pala. Hindi man lang kami binigyan eh. Kaya nung tinanong ko po yung aking mga kasama, kayo pala binigyan, bigyan nyo nga ako ng kopya para mabasa ko. Wala rin kami. Paano nyo pinirmahan? O hindi naman namin binasa nung pinirmahan na. Basta meron lang binigay ng mga signature pages. Doon lang kami pumirma. So
Well,
hindi nyo nabasa? Hindi.
God and the world has a way of correcting itself because now I have the privilege of serving the people here, not as a salimpusa, and definitely, Your Honor, as chairman of the Senate Blue Ribbon Committee, is not a salimpusa here in the Senate. In fact, you are an esteemed neophyte with a very powerful committee. So, again, number 3 is just a simple walang salimpusa rule, which is very good. Number 4, respondent have the opportunity to be heard on the draft articles of impeachment. Hindi ko na po babasahin dahil mahaba, pero basically ang sabi ng Supreme Court dito, hindi naman kailangan pumunta doon ang Vice President. Pwedeng through pleadings. Meron po bang masama dito, Mr. President, na kapag may na-impeach, bigyan man lang siya ng kopya at pasagutin muna siya sa House bago siya pasagutin sa Senate? May masama po ba dito?
Wala pong masama, Mr. President. Ang totoo nga po, sinasabi nga na dapat i-repair po lahat ng impeachment complaints kahit na yung pinirmahan ng 1/3 o higit pa, i-repair sa Committee on Justice. Yun po ang paraan siguro para magkaroon man lang ng pagkakataon ng Vice President, kahit na by pleadings lang, makasagot siya.
Yeah.
Pero hindi nga po ibinigay.
Before I go to number 5, just because I like your answer, Mr. President, one thing that guides me, no? So I've in coming to my decision with this, I follow 2 books. One, the Bible, which is of course a covenant between God and people, tayo, and the Constitution, which is a covenant among the Filipino people and the government, no? Alam mo, both books talk about due process. Ang Panginoon, nung kinain ni Adam at Eve yung prohibited fruit, nagtanong muna siya, ba't kayo nagtatago? Hindi nag-accuse, nagtanong muna, pero alam na ng Diyos. So ang ibig lang sabihin ng due process, sabi ng desisyon ng Supreme Court, magtanong ka muna bago ka humusga. So Mr. President, I was thinking, what if naging masyadong emotional yung eleksyon ng huli? And one-third of members of Congress ay naging anti-administration at ang kinahaharap natin ngayon ay isang impeachment labang kay President Marcos at pag siya'y na-impeach, magiging presidente si Vice President Sara. I wonder if all of us in this room and out of this room will still have the same paninindigan. I hope I will. I'm not judging. I am just saying, Mr. President, what helps me is those 2 books, but also to put myself in the opposite side, to put myself in that position. What if, so I'm looking, I see my good friend, former Senate President Subiri, shaking his head. So natanaw ko tuloy si Senator Kiko. What if Vice President Lenny and Senator Kiko won in 2022. And what if ang ini-impeach ngayon ay si Senator Kiko? I hope yung decision ko to support this decision would be the same.
Tama
Because
po, dapat walang pagkakaiba.
Wala saan pagkakaiba. So number 5, a reasonable period of time determined on the basis of complexity of charges must be given to all members of Congress. Kasi lumalabas po, yes, tama si Senator Soto, ibang mode yung 1/3. Pero lumalabas po mismo sa pleadings, mismo sa sinabi ng House of Representatives, wala pang 3 oras. Yung
Wala po.
ibinigay sa mahigit 200 na pumirma, samantalang ang complaint is a few hundred pages. Tama po ba?
Mahaba pong pahina lahat ang sinabi sa akin, Mr. President, at hindi po nila nakayang basahin sapagkat wala nga silang kopya. Humihingi po sila ng kopya bago pumirma, ngunit wala pong ibinigay. Yun po yung sinabi sa akin ng mga ilan sa aking mga kasamahan doon.
Yung number 6 po, Mr. President, madali kasi kailangan yung impeachable act is an act done while they were in their present office. So wala naman pong problema dyan. Meaning, kung may nagawa si Senator Cruz nung konsyal pa siya, pero ngayon Vice President na siya, hindi naman siya pwedeng impeach base sa ginawa niya nung konsyal siya.
Tama po.
So madali po yon. Number 7, at the very least to accord the opportunity to be heard under the requirement of due process in the procedure under Article 11, Section 3, Paragraph 4, after the draft Articles of Impeachment and required proof arrived at. Letter A, the House of Representatives should provide a copy of the draft articles and its accompanying evidence to the respondent and give her an opportunity to respond within a reasonable period. May problema po ba dito?
Wala po.
Kapag ka ganito kabigat, natatanggalin mo ang isang impeachable officers, tama po ba yung surprise?
Hindi po.
Parang, eto yung wag mo nang tignan, 1/3 naman kami, sa Senado ka na, sa Senado ka na mag-reply. Letter B simply states that all members, again, it's the walang saling pusa. So, Mr. President, in other words, it is not true that it is now too difficult. Sundin lang yung page 93, 94. Whether it's February 6 for the Vice President or if anyone wants to file an impeachment against anyone, magagawa to at any time.
Tama po, Mr. President.
Let me reverse my question, Mr. President. Dapat ba maging madali mag-impeach ng isang officer? I'm asking, of course, your opinion that I value, Mr. President.
Depende po sa ini-impeach na opisyal. Pero kinakailangan po hindi dapat magmadali. Kaya dalawa po kasing bagay yun eh. Kailangan po siyang mapagbigyan ng due process niya at gaano man po karami yung ebidensyang inaharap sa kanya. Bigyan natin siya ng pagkakataong makasagot. So maaari pong mahirapan ng konti, tumagal ng konti. Ngunit kailangan po natin ibigay lahat ng proseso sa ini-impeach at sa mga nag-i-impeach.
I value your answer on due process, Mr. President, and that's my second point. But if you would just also accept, or maybe I can put on record, I'm of the personal view, hindi dapat maging madali mag-impeach ng isang impeachable officer. Bakit po? Unang-una, iilan lang po sila sa ating bansa. Ombudsman, member of constitutional commissions, President, Vice President, Supreme Court. Hindi dapat madali dahil it's an extraordinary remedy in extraordinary circumstance not to penalize them, but para protektahan ng ating bansa at para nga po alisin sila sa equation if they will damage our country. So, the difference po with this impeachment sa iba, at least the impeachment of President Estrada, President Arroyo, and again, may I be sensitive especially to my friends here who are of that administration, was with us, against us, or like Senator Jinggoy and Senator JV. Yung feeling kasi doon is that if there was another day na hindi na-impeach, magagamit yung opisina na yon. Kasi presidente pinag-uusapan. Ganon din sa Chief Justice, na habang nandun ka, ma-influensyan mo yung korte. Pero pag pinag-uusapan mo Vice President ngayon, wala naman siyang hawak na departamento. Wala siyang hawak na agency. Wala namang police, militar, NBI, Coast Guard, whatever under sa kanya. Yes, we should hold her accountable kung may ginawang mali. Dapat i-impeach pag may ginawang mali. Pero it's not true that today and tomorrow matters that much. Because wala naman siyang opisina na magagamit not only to cover her tracks or to damage the country. Di ba? In fact, I doubt kung walang perpetual disqualification yan, baka iba ang suma natin ngayon. But I don't want to go to the political aspect. The point I want to make, Mr. President, is para tayong nag-Goldilocks, pag gusto natin yung i-impeach natin, so nung time na yon na gustong impeach si President Erap, padaliin natin. At kung hindi, walk out tayo. Oh. Kung kakampi mo si GMA, pahirapan natin. Kung kakampi mo si Duterte, pahirapan natin, di ba? So, in that point, I see why the Supreme Court, they made a statement Nag-statement sila about history. Sabi ng Supreme Court, ito po, sa page 94, we understand our history. We have learned that in the past, momentary desires to do what is convenient and concede means to ends have inadvertently created precedents that weaken the succor of law for those who dissent, or those that are society's margins, or those who have fallen out of grace from the powers that be. We have learned that the clash of political interests in the past, often disguised by noble intentions, have obscured the need to address the real problems of corruption, inequality, poverty, and disempowerment faced by our people. Kung ito lang po ang sinabi nila, Mr. President, sasabihin kong hindi ba namumulitika yung korte? But sinabi nila to after page 93 na iniisa-isa nila paano mo i-impeach eh. So parang ang tinuruan na ang Senado at saka House, gusto niyo impeach ang Vice President o sino man, sundin niyo lang to. Wala na kayong problema. So I think in that sense, Mr. President, it's a balanced decision. Ang question, Mr. President, yung tanong ni Senate Minority Leader, former Senate President Soto, operative fact, Mr. President. Mr. President, may I venture to answer the question of Senator Soto nung tinanong niya, ano to? Diba? Ano to yung nag-robe, etc. Nasagot na po kasi ni Sara Geronimo yon. Nung sinabi niya kay Coco Martin, there was never an us. There was never an us. Sinabi kasi ng Supreme Court na void ab initio to. But I have a reason, Mr. Minority Leader, former Senate President, and Senator Ping, why I bring this up. Because I agree with Senator Ping na ano ang i-dismiss natin. Because ang sinasabi ng Supreme Court, and that goes to my last point, for your consideration, Senator Marcoleta, sabi ng Supreme Court, there was never an us, ibig sabihin, void ab initio. So wala tayong i-dismiss. So theoretically, if we do not do anything today, we are following the Supreme Court decision. Except, yeah, that's why I'm agreeing with you. So agree with me when I'm agreeing with you, Mr. Senate President, and Senator Ping. However, human nature is that if we do not do anything, people will say it's pending. And we do have the 1 year one filing bar. So the Constitution did not intend that every single day of your life as ombudsman, as vice president, president, may nakatutok sa yung impeachment. So it is also fair to the vice president that we dispose of this. The question now is, if it is void ab initio, why did the Supreme Court not apply the doctrine of operative fact? In my research, 2 reasons. One, hindi po bringing up ng House of Representatives ito. Bringing up po to ng House of Representatives later on in the MR. Number 2, there is a rule that kapag ka magkakaroon ng injustice or may ma-oppress, hindi pwede yung operative fact. So since my finding, please correct me, Senator Marcoleta, if I'm wrong. Since my finding po ang Supreme Court na sinircumvent yung 1-year bar, hindi ka ngayon pwede mag-operative fact kasi para mo ni-reward ngayon yung circumvention. Am I correct sa
Yes,
pagkaintindi?
Mr. President, because the doctrine of operative fact is based on equity and fairness. Wala pong equity talaga eh. Hindi po sinunod ang mga tuntunin. So, sa umpisa pa lang, nagpalusot na, kaya hindi po pwedeng gamitin yung operative fact.
I see former Secretary Jeremiah Bellica in the crowd. Sa ease of doing business na si Majority Leader and si Senator Ping, I think were the sponsors, di ba, or the authors of the law. I don't know kung, ang alam ko, covered ang Congress dun eh. So kapag ka 10 days, at kasi ministerial yung sabi ng Supreme Court eh. Kapag ka nag-file ka ng impeachment, yung 10-day, 3-day, ministerial yon. So even if you do not consider it archived, if you apply the ease of doing business law that Secretary Jeremiah Bellica used to very much push in government, you would come to the same conclusion. Eh. My point is, Mr. President, we'll never come out with a perfect decision. People will disagree. That's why I agree with the statement of the IBP na ang kailangan sa Constitution ay hindi agreement, kung hindi adherence. The North and South of the United States did not agree on slavery. That's why they fought a civil war. Because they had to see who will adhere to this Constitution, who will treat this piece of paper as a living soul and a covenant of this country rather than just a piece of paper. And grabe po ang devastation sa United States. Buti po tayo nagdidebate lang. Buti po tayo yung dugo ng ating mga bayani ay minsan lang po inalay at ngayon nagdidebate na lang tayo sa desisyon na to. Pero kung hindi natin susundin ang Supreme Court decision and we will court a constitutional crisis, we will tear the Constitution apart because, Mr. President, this is going to second to the last question. May option ba tayo not to follow the Supreme Court?
Wala po, Mr. President.
So it's for academic discussion and for criticism, for enlightenment, and trying to influence the court na masama decision nyo. In accordance, I respect the opinions for those who think na masama yung decision. But in actuality, as an institution, we have to follow, hindi po ba?
Tama po, Mr. President.
Is the gentleman a member of the Commission on Appointments?
Wala pa po yatang ini-elect.
Hindi, kasi may desisyon ang Supreme Court kung paano hati-hatiin yung membership ng CA. Kung hindi rin natin susundin yung desisyon ng Supreme Court sa impeachment, wag na rin natin sundin sa CA. What about sa sweldo ng mga senador? Di ba, sabi sa konstitusyon, sa mga batas, hindi tayo pwede magpasa ng batas na makikinabang tayo.
Tama po yun.
So kung disagree tayo, wag na rin natin sundin dahil mas mataas na sweldo yun.
Kailangan po kasi palagi nating isasaalang-alang kung anong sinasabi ng desisyon ng Korte Suprema at hindi yung sarili po nating nilalayon o ang sarili nating interes.
Correct ko ba? Especially when we disagree. Madali kasi magsang-ayon pag we agree eh.
Tama po.
Maraming magsasabing nag-uusap tayo through microphone but we agree on many things. But mas mahirap when we disagree.
Tama
So,
po.
Mr. President, so since we disagree slightly on dismiss, would the movant, the distinguished senator, consider na ma-amend yung motion that the Senate obey or follow or anong tamang salita na acceptable sa minority, the Supreme Court decision? Because if the motion is to obey the Supreme Court, so if the Supreme Court reconsiders, the motion still carries, then we will follow. If they don't, we will still follow. And right now, sabi naman nila, it is immediately executory. So as far as I'm concerned, it doesn't exist. But I agree with the gentleman, there's some action that is wanting eh. Kung
Tama
hindi
po.
kung hindi, it's there floating in the air. Anyway, I'll leave that as a question. There might be some people who want to interpolate, Mr. President, but may I offer that solution? We are allowed to amend, to propose an amendment to any motion if the movant agrees.
I am amenable to an amendment, Mr. President, like moving it to send it to the archives. Like we will have the same result, if that is the case. And I will be pleasing Senator Soto if I do that.
What is the pleasure of the Honorable Soto, the distinguished Minority Floor Leader?
Thank you, Mr. President. It grieves my heart to disagree. I think I'd rather call for the previous question, a motion to table. It has the same effect, and you can bring it up anytime. But we did not say that we did not follow the Supreme Court decision. It will not. It will not say that we archived, as the interpretation of the Supreme Court is kung ano yung word ng archive. Iba yung archive nila eh. Hindi pa nga adjourn, archive na sa kanila eh. Hindi ba? Hindi pa tapos yung session eh. Hindi naman ganun ang archive sa atin. Sa kanila ganun. Iba yung rules ng Congress eh. Iba yung kaysa sa rules nila eh. So, hopefully, baka pwedeng we can find a middle ground between the proposal of Senator Alan Cayetano and my motion to table, which has a higher precedence than the motion to dismiss.
But Mr. President, that is not consistent with the immediate character of the decision. The decision says it is immediately executory. A motion to table, hindi po immediate yun eh. Tsaka sabi nga ni Senator Cayetano, somehow there should be some action. The people are waiting for some kind of a closure before this chamber. Because that particular decision is directed to no one but to the Senate, Mr. President.
Sir President.
Before the chair recognizes any member, the parliamentary status is that a motion was made by the Honorable Marcoleta, which he is willing to amend, and a higher order of precedence motion was made by the Honorable Minority Floor Leader. Both are pending, and to afford time for both the Minority Leader and the original movant to perhaps consider and find a compromise as agreed upon earlier, can we proceed with the interpolations and interjections, manifestations, if you will,
Yes,
of the
yes.
other members who had manifested to so interject and make known their position through a manifestation or interpolation?
Yes, Mr. President.
Thank you.
Therefore, I withdraw the call for the previous question, and then allow that to proceed. But then again, just a point of information for our colleagues. The Supreme Court has just received a motion for a TRO for the Senate not to take up this particular case. It was filed yesterday by the former Associate Senior Justice Tony Carpio, also Ombudsman Conchita Carpo Morales, Commissioner Heidi Mendoza, religious leaders, former military and public servants, Ms. Sheila Magno, students and the youth and the academe. They have filed a TRO with the Supreme Court, and we are awaiting something to that effect. It might come out today, and then we are, again, inuunahan natin. So hopefully, yes, we can proceed, Mr. President.
Thank you, Minority Floor Leader. Your manifestation is duly noted. Senator Cayetano,
Sir President, let me agree
wind
with...
up.
Let me just agree with both you and the Minority Leader. And of course, thank Senator Marcoleta for his openness. Ang intention ko lang naman po in proposing an amendment, wala pa yung actual words, no? But, Mr. President, kasi kung pwede, pag bumoto tayo, dahil mabigat po yung pagbobotohan natin at most of us have dug in already sa legal opinion natin sa boto natin. So kung mali ang framing kung ano pagbobotohan, mahirapan din tayo lahat. So meaning I don't mind if I vote for or against the proposition, at least malinaw kung anong pagbobotohan ko. So like I would vote to follow the Supreme Court decision I'm thinking whether I'll vote to dismiss because the Supreme Court said it did not exist, void ab initio. But I don't want to vote against it because if I vote against it, it is live. And precisely the Supreme Court said immediately executory. No? So let me yield the floor para dun makapagtanong yung iba. But I'm hoping some of us can come up with language that will be acceptable. We might not have a unanimous vote, but at least klaro kung anong pinagbobotohan natin. Thank you very much, Senator Marcoleta.
Mr. President, just a point of information.
Senator Pia Cayetano is recognized for her point of information.
Yes, thank you, Mr. President. I'm happy to be corrected. We have on the floor, I don't know, maybe 5 or 6 previous majority floor leaders. Senator Alan was a majority floor leader. The minority floor leader was Senator Soto was a majority floor leader. Senator Kiko was a majority floor leader. Senator Subiri, former Senate President, was also a majority floor leader. I hope I didn't forget anyone. Lauren was a majority floor leader. So on that note, I just want, so again, I'm happy to be corrected, but the rules, to my knowledge, do not limit us to a particular kind of motion. Rule 31, the title is Precedence of Motions, so it lists the motions that take precedence. Rule 32 is the privilege motion. It doesn't mean that we cannot have a different motion. So just put that on the table so that those who want to be creative can continue this discussion later on when we get to that point that we are deciding if we will rephrase, if we choose to look for a more appropriate wording, but I'd like to include this in everyone's for everyone's consideration that there doesn't seem to be a limitation on what kind of motion we can present to the body. Thank you.
Thank you very much, Senator Cayetano. Mr. President, at this juncture, may I move that we recognize the distinguished gentleman from Davao, Senator Bato de la Rosa.
Senator De La Rosa is recognized. What is your pleasure, sir?
Thank you, Mr. President. I just would like to make a clarification, Mr. President, that it is very clear to me during our caucus, we have agreed that today, on this date, we are going to tackle this Supreme Court ruling, and we have to debate on this, and we have to decide on this today. It was not part of the agreement that whenever the House of Representatives file a motion for reconsideration, ay ma-install yung ating plano to decide today. So, bakit nagbago yung usapan, Mr. President? I'm just asking.
Your Honor, the Senate is a collegial body and decides everything by dividing the House. The current parliamentary status is that we have 2 motions that have not yet been acted upon. One has precedence over the other. Pinahintulutan ng dalawang movement na magpatuloy muna yung pagdedebate. So darating po tayo sa punto, matapos ang debate, na pagbobotohan natin yung dalawang motion po na yan. Ayon sa precedence ng rules natin. Majority Floor Leader.
Mr. President, just very quickly.
Mr. President,
Very quickly.
Is this already your...
Just
I
an
think-
interjection on the point raised by Senator De La Rosa.
Mr.
Majority
President,
Leader.
if I may appeal, Mr. President, to distinguished gentleman from Pampanga, Mr. President, because next to interpolate is the distinguished lady from Iloilo, Mr. President,
quick
Senator Risa, and
manifestation.
then it's his turn, Mr. President.
Just a quick manifestation,
The
Mr. President.
gentleman may proceed for his quick manifestation.
Because it has been referred repeatedly about what we agreed on in the caucus. Mr. President, we agreed to decide on this matter. And if the decision is to lay it on the table, that is a decision of the Senate in plenary. In other words, we didn't agree on deciding that we will decide on a motion to dismiss. We didn't agree that we would decide on holding it in abeyance. We said we will decide.
Your Honor, that's precisely what the chair said. We will be
Thank you.
deciding on these pending motions at the proper time after debate. Senator Ontiveros
Yes,
is recognized for her interpolation and interjection if Senator Marcoleta so desires.
Yes, Mr. President.
Salamat po, Mr. President. In lieu of an interpellation of the good gentleman from Tarlac, I will be seconding a motion, Mr. President, preceded by a brief manifestation. Earlier, Mr. President, Senator Marcoleta said he refuses to speculate on reversal. But the good gentleman's own position is based on his own speculation that the SC will not reverse its decision. A tabling of the motion to dismiss, which is what I will second in a few minutes, Mr. President, a tabling of the motion to dismiss by the Senate today is not defiance of the Supreme Court. Wala pa nga po kasing final na decision. Kahit ang Korte Suprema po, iniintay pa ang comment ng VP. That is why I will be seconding the motion of the Minority Leader to table the motion to dismiss the impeachment complaint until the decision of the Supreme Court has attained finality. Tama po, we should exercise extraordinary prudence in this matter of transcendental importance. Still, I also wish to take this opportunity to express my thoughts at this crucial moment for our chamber. Mr. President, I agree and I continue to respect the Supreme Court. Hindi po magbabago iyan. But, Mr. President, hindi naman po ibig sabihin ng respeto ay pananahimik. Lalo na kapag inisip natin kung gaano kalaki ang nakataya dito. Magkaiba rin yung rumerespeto at yung bulag. Kaya naman, I will not be choosing silence, nor will I be turning a blind eye in the face of clear and unmistakable injustice. I am encouraged by the words of brave professors of the UP College of Law who in 2010 issued a sharp critique of a Supreme Court decision, Vinuya versus Executive Secretary, which said, the court cannot regain its credibility and maintain its moral authority without ensuring that its own conduct, whether collectively or through its members, is beyond reproach. So, in the context of the SC decision, Duterte versus House of Representatives, I believe we need to shed light on some concerns which former justices and constitutional framers themselves, some of whom are here this afternoon, Mr. President, have underscored. Una, the Supreme Court decision was based on critical factual errors. At binanggit na rin po ito ni Minority Leader. And this has since been pointed out by no less than retired Senior Associate Justice Antonio Carpio. For example, the decision said that the February 5 impeachment complaint was transmitted to the Senate without a plenary vote in the House. A simple check of the records, specifically House Journal number 36, shows that this is false. Walang haka-haka. Those official records are plain for anyone to see. Sabi tuloy ni retired Chief Justice Renato Espuno, na siyang chairman ng Philippine Constitution Association, the Supreme Court was faced with a famine of facts necessary to make a decision invulnerable to constitutional assaults. Pangalawa, actions already taken under a prior and valid interpretation should be recognized as legally effective. Yan naman ay mula kay retired Justice Adolf Ascuna. The House of Representatives was operating under the regime of the legal doctrines in Francisco and Gutierrez, which held that the initiation of impeachment proceedings begins from referral. Kung unconstitutional pala na sundin ang legal doctrines, in the words of Justice Ascuna, that is legally unfair. Paano nga naman unconstitutional kung sinunod lang nila ang patakaran ng mismong Korte Suprema? Dagdag pa po sa isang desisyon nitong 2020 lamang, Madreo versus Byron. Sabi ng Korte na kung may pagbabago sa doktrina at interpretasyon ng batas, dapat prospective ang aplikasyon nito. At ang pangatlo at huling punto, mistulang nadagdagan ang requirements sa proseso ng impeachment na hindi naman nakasaad sa ating saligang batas. These new limitations, Mr. President, are not found in our fundamental law. Wala yan sa konstitusyon at kontra yan sa accountability. One disturbing example, sabi ng desisyon, Kailangan daw na isumite na ang bawat ebidensya laban sa opisyales sa pag-file pa lang ng complaint sa House. Dapat ba naka-attach na ang bawat bank slip, public record o testimonya ng witness na ihaharap kahit wala pa silang proteksyon ng Senate Impeachment Court? Ang tanong tuloy ng marami, realistic ba yan? Paano kung ang impeachment ay laban sa mataas na opisyal na kayang-kayang magtago ng ebidensya o manakot ng mga potential witness? Bakit humaba yata ang checklist ng proteksyon para lang sa impeachable officials? Samantalang ang taong bayan na nagtatanong, na naniningil ng pananagutan, sila pa ang pinahirapan. Sila pa ang nadagdagan ang requirements. Ayon sa Korte Suprema, an official facing impeachment does not stand to lose fundamental constitutional rights such as life, liberty, or property. Hindi buhay, kalayaan, o pag-aari ang inihahabla sa impeachment. Kung ang usapan naman ay due process, hindi pat ang mismong impeachment trial na nga ang mismong venue para doon. Maririnig ang dalawang panig. May ebidensya, may magdedepensa. That is due process. So what are we afraid of? At dahil nandito rin po sa gallery ngayon, Mr. President, ang isa sa mga constitutional commissioners na si Christian Monsod, di lalo po akong confident na mag-take exception sa isang sinabi kanina ng good gentleman mula sa Taguig at Pateros na dapat mahirap ang proseso ng impeachment. Kontra po doon ang pananaw ng Constitutional Commission kung mababasa po natin ang records ng deliberations ng komisyon, partikular sa panig ni Commissioner Regalado. Muli, patuloy nating nirerespeto ang Korte Suprema. Pero pwede mong respetuhin ang isang institusyon habang nagtatanong at pinag-uusapan ang kanyang desisyon. In Firestone Ceramics Inc. versus Court of Appeals, the court conceded that it is not infallible. Should any error of judgment be perceived, sabi nila, it does not blindly adhere to such error. In this jurisdiction, rectification of an error more than anything else is of paramount importance. In the 2010 letter that I mentioned earlier, the UP law professors said that the position of the Supreme Court as the final arbiter of all controversies requires competence and integrity completely above any and all reproach. A breach of these values, the professor said, does violence to the primordial function of the Supreme Court as the ultimate dispenser of justice. And the UP Law Dean who led that letter to the Supreme Court, walang iba po kundi ang nagsulat ng desisyon na ating pinag-uusapan. Dear Mr. President, dear colleagues, I believe this decision is of the highest public interest, whose consequences will echo through time and history. Maraming taon mula ngayon, pag-aaralan at hihimayin ito ng lahat. Mula sa mga estudyante, mga journalist, mga political analyst, mga academics, at higit sa lahat ng ating mga kababayan. One day, and this day will come, history will judge all of us based on our actions today, August 6, 2025. When history comes to remember, let's hope we stood where it mattered, that even in the face of doubt, we did what was right and just, with deep respect for the Supreme Court and all institutions of our country, Mr. President. I therefore second the motion to table the motion to dismiss the impeachment complaint until the decision of the Supreme Court has attained finality. Salamat po, Mr. President.
Mr. President, quick reaction.
Noted and entered into the records. Senator Marcoleta.
Mr. President, unang-una, yung sinabi ko pong speculative, sapagkat it was not based on my own speculation. It was based on my long practice as a litigation lawyer. Wala pa po akong nakitang isang unanimous decision. Ewan ko lamang po kung merong magbo-volunteer ngayon na abogado in the last 40 years na sinasabi ang isang unanimous decision na ang karakter niya ay sinabi na ab initio, void ab initio, unconstitutional, violative of due process. Maybe if we can speculate that all the members of the Supreme Court, after the filing of the motion for reconsideration, will resort to their worst, will resort to the worst angels of their nature. Maybe, baka ganun lang. What do we expect? We expect that 8 of them will reverse themselves altogether. Kung sakasakali naman po na in-archive natin or whatever word is applicable at sinabi, under miraculous circumstances, sinabi ng Supreme Court, we are all reversing ourselves. Di continue natin. Anong problema? Pero kagaya po na sinasabi ko kanina, Mr. President, ang pagkakaluto nga po hilaw eh. Ipinipilit po ngayong ipakain sa Senado ang isang bagay na hilaw. Paano? Sinabi po ba ng Supreme Court na wag na kayong mag-impeach? Hindi po. Binigyan po tayo ng guidelines. Alam po ba ninyo kung bakit binigyan na ng guidelines ng Supreme Court kung paano mag-impeach? Kasi po, Mr. President, if you recall, the Supreme Court issued a notice on July 8, 2025, requiring at least 11 information from the House of Representatives and the Senate. The Senate made a manifestation na wala po kaming maibibigay sapagkat lahat po niyan ay makukuha ninyo sa House of Representatives. Alam po ba ninyo na 4 sa hinihingi ng Supreme Court ay nandun po sa puso ng due process? Ano po yung hinihingi? Sinabi lamang po ng Supreme Court, pwede bang ibigay nyo sa amin kung lahat ng miyembro ng House of Representatives ay binigyan ninyo ng kopya at kailan? Pwede bang ibigay nyo sa amin ang timing kung kailan nyo ibinigay at binigyan, kung paano nyo sila binigyan ng pagkakataong mabasa yung impeachment complaint? Pwede nyo bang ibigay sa amin kung every article of impeachment ay nakalagay doon ang mga dokumento na nagpapatibay ng artikulo? Pwede nyo bang ibigay sa amin kung nagkaroon sila ng pagkakataon talaga na mabasa yung impeachment complaint? Alam po ba ninyo kung anong sagot ng Solicitor General in behalf of the House of Representatives? Ito po yung sagot nila. It is the position of the House that these matters pertain to its internal proceedings, which have always been regarded as beyond the jurisdiction and scrutiny of this honorable court. Sa Tagalog po, wala po kayong pakialam dito sa amin. Yung inihingi po ninyo, kami lang po yun. Para tinatanong lang naman po eh. Binigyan nyo ba ng pagkakataon sila na mabasa? Bakit? Mahirap po ba sagutin yun? Ano pa po sinabi? This is especially because the matters referred to, the preparation, circulation, and perusal of the impeachment complaint, as well as its attachment, are not governed by specific constitutional provision or the House rules. So dahil po wala sa Constitution at wala rin po sa House rules, ano po yun? Wardi-wardi na lang. So ibig sabihin talaga, kaya po pala ang dami kong kasama doon, wala talaga silang kopya. Ako nga po hindi nabigyan eh. Bakit hindi po kinakailangan bigyan lahat? Baka sakaling, malay po ninyo, baka pumirma ako, hindi ba? Ito yung tinatanong po ng Korte Suprema. Kaya lang po siya nakapagbigay ng additional guideline sapagkat isip-isipin nyo, sasabihin sa Korte, wala nang pong masamang tinapay ang Korte. Pwede po malaman namin kung talaga nagkaroon ng pagkakatong mabasa man niya lang, ma-appreciate ang bawat dokumento na nakasalig dyan sa impeachment na yan. Para sa ganun, ay boboto siya sang-ayon sa kanyang sariling kagustuhan. Matibay ang gusto ng Korte Suprema. Gusto niyang makita na lahat ay dumaan sa kayusan. Hilaw nga po Mr. President. Kanina ko pa po pinaiintindi, hilaw. Ba't hindi po kayo magluto ng mas masarap na kanin? Para sa ganun po, hindi tayo mahirapan. Maghintay na lang po kayo ng 6 months. Pwede naman Ba't pinipilit po natin ng isang bagay na hilaw at pinipilit niyong ipakain sa atin? Mr. President. Sabi ko po kanina, Mr. President, I am ready to amend my motion kung kinakailangan po, that will be consistent on the respect accorded to the Supreme Court. Kaya lamang po, kailangan nating umaksyon sapagkat kagaya po ng nalalaman natin, naghihintay ang taong bayan na kailangan magkaroon po ng closure ito sapagkat kapag ito will be hanging on the balance, baka hindi po mabutihin ang ating mamamayan. Yun lang naman po ang pinakapunto rito, Mr. President.
Thank you, Senator Marcoleta.
Mr. President.
What is the pleasure of the minority floor leader?
Thank you, Mr. President. Caution is the word simply being put forth by this representation, Mr. President. Because again, sabi nga, wala pa raw siyang nakita. The distinguished gentleman from Tarlac, with due respect, said wala pa siya nakita na unanimous decision ng Supreme Court na baliktad. No? Again, I said, there's always a first time. Oh, bakit ko sinasabi ito? I will quote the Supreme Court themselves. In De Pedro versus Romasan Development Corporation, GR 194751, July 1, 2015, I quote, Supreme Court nagsabi nito, while the Supreme Court's decisions are immediately executory, they are not considered final until the lapse of the prescribed period without a motion for reconsideration or upon denial of such motion. Sila nga mismo nagsasabi na hindi final eh. Ano ba naman ang masama na maghintay tayo na kung final na? For all you know, I might vote on the motion to dismiss. Hindi ba? If there is such a motion, because according to Senator Lacson, it does not exist in the Senate. It exists in the impeachment court. And what I am being told is that it should be the defense, the lawyers of the defense who should pose that motion to dismiss, not a judge. I agree with Senator Lacson. There is no such thing as a motion to dismiss in the Senate. In the impeachment court, yes. Thank you, Mr. President.
Hindi po ba inamid na natin, Mr.
By the way,
President?
just one last point. Why did the Supreme Court ask Sara to comment? Kung final and executory na yan, bakit si Vice President Sara was asked to comment by the Supreme Court just a few days ago? Di ba? So, ibig sabihin, talagang pakikinggan pa nila. At baka sakali makita nila, dahil yung mga abogadong nakapaligid sa kanila, nagbigay sa kanila ng mga maling figures at maling impormasyon.
Mr.
By way of point-
President, kaya nga po nag-i-speculate tayo rito eh. Hindi natin alam kung anong iniisip ng Supreme Court. Pero sa ngayon, sinabi po niya, immediately executory at tayo lamang po talaga ang pinagsasabihan niya. At tungkol naman po sa motion to dismiss na minodify ko na kung ayaw po ninyo, wala po akong magagawa. Pero may I invoke Section 135 of the Senate Rules. Ang sabi po rito, if there is no rule applicable to a specific case, the proceedings of the Legislative Department of the Philippines shall be resorted to. So ang dami po nito eh. Dito po magkakaroon ng motion to dismiss dito. Lahat po ng precedents, kahit na wala po tayong specific rules, ay observe po natin ang Section 135 ng ating rules. Pero dahil inamend ko na nga po, kung pwede na po yung motion to archive, which is consistent to the immediate execution of the decision of the Supreme Court addressed to this august chamber. Oy, bakit naman po pinipilit pa nating i-delay based on speculation? Based on the fortunes of whatever the Supreme Court will decide later on, which is based on impossibility.
Noted and entered into the records.
Mr. President. Just
What is
for-
the pleasure of the Honorable Cayetano?
Just 1 minute, Mr. President. Just for the information of the body, there's actually a Supreme Court case about the power to dismiss a case. Ito po yung Velasquez Jr. versus Lisondra Land 2020 case. Ang sabi niya, in order for the court or an adjudicative body to have authority to dispose of the case on the merits, it must acquire jurisdiction over the subject matter. It is axiomatic that the jurisdiction over subject matter is conferred by law and not by the consent or acquiescence of any or all of the parties or by erroneous belief of the court that it exists. Thus, when a court or tribunal has no jurisdiction over the subject matter, the only power it has is to dismiss the action. So Supreme Court na mismo nagsasabi na pag walang jurisdiction, it does not exist. So sabi ng Supreme Court dito, void ab initio yung Articles of Impeachment. Pag tinitingnan natin rules natin, the impeachment court is triggered by an Articles of Impeachment. Kung walang Article of Impeachment, walang court. So yes, it's true na it is a fact, not an operative fact. It is a fact na nag-robe tayo, nandito tayo. It is not an operative fact na meron tayong jurisdiction doon. Lastly, Mr. President, sa Rule 39, Section 4, judgment not stayed by appeal. Judgments in actions for injunction, receivership, accounting, support, and such other judgments that are now or hereafter be declared to be immediately executory shall be enforceable after their rendition and shall not be stayed by an appeal. Some may say this is for injunction, receivership, etc., and not for the impeachment court. Ang point ko lang, Mr. President,
Your Honor,
meron naman tayong...
This is a case for injunction.
Yes.
Filed by the Vice President against both the Senate and the House.
Thank you for that clarification. But even if it was not, Mr. President, that is why if we... The gentleman from Tarlac already said he's amendable. So kung halimbawa something like we move to act upon the Supreme Court decision and archive the case. Kasi yung Supreme Court decision, when you act upon, ano ba sabi niya? Immediately executory. Ano ba sabi niya? Void ab initio. Ngayon, kung halimbawa na-reconsider at biglang sinabing tuloy, wala rin naman na epekto yon sa motion na we act upon the Supreme Court. Then at the proper time, someone can say here, we will act upon the latest decision of the Supreme Court. Diba? So I'm just saying this in the spirit, Mr. President, na pag nakaboto tayo, at least klaro kung anong pinagbobotohan because some of us might not vote for the motion to dismiss just because we believe there is no such thing as a motion to dismiss. But I don't think that's our point. Our point is lagyan ng katahimikan to for a few months. February 6, game na ulit.
Noted and entered into the records. Majority Floor Leader.
Thank you, Mr. President. Next to interpolate, Mr. President, is the distinguished gentleman from Pampanga, but the gentleman from Pampanga is yielding the floor to our Deputy Minority Leader.
Yes, what is the pleasure of the Honorable Antiveros?
Thank you, Mr. President, and to the good gentleman from Pampanga. Gusto ko lang pong bigyan ng point of information, sagot dun sa tanong ng good gentleman mula sa Tarlac, that in fact, the Supreme Court has reversed a unanimous decision in a lot of instances before. Dalawa lang po ang ibibigay kong halimbawa. League of Cities of the Philippines versus COMELEC. Original decision, 2008. Reversal on motion for reconsideration 2009. Isa pa pong halimbawa, International Service for the Acquisition of Agri-Biotech Applications Inc. o ISAA et al. Versus Greenpeace Southeast Asia. Original decision, unanimous, December 8, 2015. Reversed unanimously on MR din, July 26, 2016. So, hindi lang po tulad nung sinabi ni Minority Leader na there's always a first time, it has happened before. So, yung ganitong klaseng milagro na hinahanap, posibleng mangyari din po dito sa kasong pinag-uusapan natin. Malay po natin. Salamat po, Mr.
Noted.
President. Salamat sa good gentleman from Tarlac.
From the
Entered
good
into the
senator,
records. Senator Marcoleta.
may I know from the good senator if these decisions are bank decisions or divisions?
Yes, Mr. President, unbanked decisions po.
Well, you have to cite the
I would gladly
jurisprudence.
cite the GR number po bang hinihingi, Mr. President?
Pagka sinabi pong bank, lahat po ng members ng Supreme Court, 15 of them, unanimous.
To
Kasi po,
reiterate what
baka division lang yan, 5 lang yun. Hindi po
No,
bank
Mr.
yun.
President, to reiterate what I already said, mga ano po ito, mga reversal ng unanimous Supreme Court decisions.
Yes, but I am
At sa
asking for
dalawang
qualification,
halimbawang
Mr.
binigay
President,
ko
whether
po
these are
on
bank
MR.
decisions or decisions by a division. And whether or not they
Mr.
were
President,
characterized by,
sinabi ko rin na po kanina ang
Sandali
bank
po.
decisions po ito. Ay, hindi po.
whether or
I am
not
replying to
the
the
decisions
question.
are characterized by the following qualifications. One, unconstitutional, void ab initio, violative of due process. All these are present in those jurisprudence cases as you cited.
Mr.
President.
Mr. President, bagamat para itong yung pinag-uusapan natin kaninang operative facts, kanina simple lang yung tanong eh. May kaso na po ba na ang Supreme Court sa unanimous decision ay ni-reverse ang sarili nila? Ngayon may dinadagdag na tanong. Pero sige po, yung League of Cities of the Philippines versus COMELEC, the Supreme Court in its original decision in 2008 unanimously declared the cityhood laws unconstitutional. I will have to get more information po on the ISAA reversal of unanimous decision. Pero malinaw na mga sagot na po ito dun sa original na tanong. So the original assertion na hindi po natin alam kung na-reverse na ng Supreme Court ang sarili nila sa original na unanimous decision has fallen by the wayside. Kasi the Supreme Court, as I said already earlier, has reversed a unanimous decision en banc in a lot of instances before. Yun lamang naman po, Mr. President.
Noted and entered
Salamat
into
po.
the records. Majority Floor Leader.
Yes, Mr. President, may I move that we recognize the next interpellator, the gentleman from Pampanga, Senator Kiko Pangilinan.
Yes,
So
Mr.
moved, Mr. President.
Senator Pangilinan is recognized and may proceed. Should the gentleman so desire?
Yes, Mr. President.
Yes, Mr. President, this is not an interpellation, but with the permission of the gentleman from Tarlac, we will just make a manifestation.
The gentleman may proceed.
Thank you, Mr. President. Mr. President, marahil marami ang nagtataka o nagtatanong ano nga ba ang pinakapunot dulo o debate na pinag-uusapan dito sa Senado. Tatlong sa probisyon ng saligang batas. Tatlong kapangyarihan ng tatlong sangay o tatlong governmental entities. Yung kapangyarihan ng judicial review ng Korte Suprema, yung sole power ng House of Representatives to initiate impeachment proceedings, at yung sole power ng Senate bilang impeachment court para litisin at pagpasyahan ang isang impeachment case. Narito tayo ngayon, nagdedebate dahil yung judicial review power ng Supreme Court ay pinawalang bisa ang sole power ng House of Representatives para ito ay mag-initiate ng impeachment proceeding, at pinawalang bisa rin ang kapangyarihan ng Senado bilang sole having the sole power to try and decide impeachment cases. Dahil dito, saan tayo tutuloy? Merong na ring mga ruling ang Korte Suprema kung paano natin iha-harmonize o ihahambing ang mga nagtatalong probisyon ng saligang batas. Sinabi ng Korte Suprema sa kaso ng Civil Liberties Union versus the Executive Secretary, pati na rin sa Francisco case versus HOR, the Constitution is to be interpreted as a whole, and one section is not to be allowed to defeat another. In this case, the judicial review should not be defeated. The sole power of the House to initiate should not be defeated. And the sole power of the Senate to try and decide cases. All mandates, all duties, all constitutional powers that do not belong to us, that was given to us not by any whim, but by the Constitution, all of whom here sworn to uphold and defend. Kaya ano ang way forward? Sabi nga, may mga minungkahi si Justice Ascuna, hayaan sa MR, payagan sa motion for reconsideration, payagan na magkaroon ng operative facts doctrine para yung anuman ang pinagpasya ng Korte Suprema sa kasong ito should apply prospectively, number one. Pangalawa ay sa pamamagitan ng MR pa rin ay mabigyan ang House of Representatives na maituloy ang kanyang kapangyarihan to initiate, and at the same time, mabigyan ang kapangyarihan ng Senado to try and decide the case. Kaya habang naririyan ang MR, baka sakali, at nangyari na nga, na the Supreme Court has reversed itself, even in a unanimous decision. But even assuming it does not reverse itself in this case, the Supreme Court may modify its ruling. And therefore, if it modifies the ruling, assuming that it modifies but does not reverse itself, should we not await the resolution of the motion for reconsideration before we vote? Today, we hold it in abeyance or we table it. Mr. President, if I may add, the SC, the Supreme Court, hindi niya binanggit. Binanggit niya nawalan ng jurisdiksyon ang Senate Impeachment Court. Pero ang ibig sabihin nun ay pinawalang bisa, ginawang void ab initio ang mga kilos at pasya ng Impeachment Court. The convening of the Impeachment Court was voided. The majority decision to remand the complaint to the HOR was voided. The summons by the Impeachment Court were all voided. Which brings us to the question, who now is deciding the impeachment case? Now that all the decisions of the Impeachment Court have been voided. It's a tricky question, Mr. President. But if I were to be an impeachment court judge, I would argue that we have to, in the MR, in the motion for reconsideration, intervene and uphold the impeachment court's exclusive power to try and decide the case. Why? Because it is the constitutional duty to do so. It is the order of the Constitution. We are not defying the judicial review powers. We are upholding the sole power of the Senate to try and decide impeachment cases. But, having said that, sabi nga, it is our view, and this is shared precisely by former Supreme Court Chief Justice Panganiban, former Chief Justice Puno, former Constitutional Commissioner and Justice Ascuna. They have seen, or they have read their decision, and they too have said that the Supreme Court erred on a matter of facts. And if the Supreme Court erred on a matter of facts, how can you be right with the law if you are wrong with the facts? And if you are not right with the law, why will the impeachment court and the Senate, for that matter, decide on the matter today? Why not wait for the motion for reconsideration? Siguro naman, hindi natin binabangga ang Supreme Court, hindi natin binabangga rin ang House of Representatives dahil meron ding prinsipyo ng parliamentary courtesy. Meron ding prinsipyo na kinakailangan natin bigyan ng respeto ang co-equal. We are a co-equal to the House of Representatives. Ano na lang ang magiging repercussion na ito ang House of Representatives nag-file ng motion for reconsideration, hinihiling nila sa Supreme Court na baguhin ang ilang mga findings of facts, baguhin ang kanilang naging desisyon habang pinangunahan ng Senado ang House of Representatives at sinabi, wala kaming pakialam sa inyong motion for reconsideration, i-dismiss namin ang kasong ito. I think, out of courtesy for a co-equal, we should respect the House of Representatives. In the same way, if the Senate would, at a future time, file a case before the Supreme Court and seeks a motion for reconsideration in a matter that involves the House, we would like to think that the House will not act to have the case dismissed pending the MR out of respect for a co-equal. Sana, pag-aralan natin ng husto ang pagpasya ngayong hapon. Sabi ko nga, the findings of grave abuse by the Supreme Court, thereby removing or taking away from us the jurisdiction, na wala tayong jurisdiction, that jurisdiction was not acquired on the basis of facts that are flawed, where then is the grave abuse? I don't know what the ruling will be. Perhaps they will say, yes, there was no grave abuse of discretion on the part of the House because of the 1-year bar, which was not actually, the fourth complaint was not bar. I don't know. But whatever it is, hintayin na lang naman sana natin. Respetuhin naman natin ang ating co-equal. Why the convening of the impeachment court is the way to go? Dahil pag tayo ay bumoto ngayong hapon o ngayong gabi na i-dismiss ito, aksyonan ang impeachment complaint, we will be acting beyond, without legal authority dahil wala naman sa atin yung impeachment complaint. Wala namang kapangyarihan ang Senado in plenary, ultra vires, without legal authority, ang magiging desisyon natin. One final point. In the Corona impeachment trial, nang himasok, nag-TRO ang Supreme Court para sa mga bank accounts. Ano ang ginawa ng Senate Impeachment Court? Bumoto 13-10 para respetuhin ang Korte Suprema. I did not vote in favor of the TRO or respecting the TRO. But the Senate, as an impeachment court, voted and we respected it. Because it was the Senate Impeachment Court that decided. It was not the Senate. It was the Senate Impeachment Court that, seeing perhaps that we needed to harmonize the power of judicial review, the power of the Senate as an impeachment court, to have the sole power rather to try and decide cases, seeing that the Senate in impeachment court decided to harmonize the conflicting provisions of the Constitution. I think we should, as a Senate impeachment court, do the same. Kung ipagbobotohan na respetuhin ng Korte Suprema para walang constitutional crisis, so be it. But it ought to be the Senate Impeachment Court that asserts its sole power to try and decide impeachment cases. Yun na lamang po, and I associate myself with the motion of the minority leader that we lay on the table the matter of the impeachment case and action.
Just a point of information, for the record and for the information of the body. Chair confirms the manifestation earlier of Senator Cayetano with respect to Section 4, Rule 39 of the Rules of Court that says that decisions of the court are not immediately executory unless the decision says so. In this case, the decision specifically stated that it is immediately executory. Number two, again, just for the record, The Supreme Court itself, through its spokesperson, after the House filed their motion for reconsideration, reiterated the immediately executory nature of the decision of the Supreme Court. And finally, the Supreme Court's own internal rules states that the entry of judgment shall be the date such decision or resolution becomes executory unless the court directs its immediate execution. I'm quoting and citing AM number 10-4-2-20 rather SC, specifically section 16, rule 16 rather, section 1. So there are conflicting authorities with respect to the opinions raised by the various members. Senator Marcoleta, what is your pleasure?
Just a quick reaction, Mr. President, on the manifestation of Senator Pangilinan. In the exercise of the Supreme Court's judicial review, wala po siyang dinidefeat doon. Hindi niya po kinukuha yung sole power of the Senate to try and hear impeachment cases. Hindi rin po niya kinukuha yung exclusive authority ng House to initiate impeachment. Dito po sa desisyon na ito, kung kinakailangan ulitin po o ulit-ulitin pa, ang sinabi lamang po ng Supreme Court, yung process, yung procedure hindi natupad. Ang dami po niyang hiningi, kagaya po ng binanggit ko na, ayaw pong ibigay. Yun naman pong mga tuntunin ay hindi naman po sinunod. Katulad nga po nung immediate referral, yung pag-refer sa Committee on Justice, yun pong pag-include sa order of business at pag-archive, mali din po sapagkat hindi naman po 10th session day yun 11th session day. Katakot-takot na paglabag po ang aking pong inihayag sa hapong ito. Wala naman pong gustong magpatibay at o kaya sansalain o kaya sabihin na mali ang aking sinasabi. And dito po yung kopya ng order of business na pinagbasihan ng Solicitor General na kung saan sinasabi po niya na yung 4 na impeachment complaints in-include daw po sa order of business. Tingnan po ninyo, wala kahit isa. Ang ginamit po nila ay journal, hindi po yung order of business na kung saan ginamit lamang po na additional reference of business. Ngayon po, yung operative pact na sinasabi natin, hindi rin po pwedeng mangyari yon sapagkat ang pinakabasihan po noon ay equity and fairness. Paano po yung fairness dito? Sari-sari nga pong violation, kaya nga ang paghahanilin tulad ko na nga, parang nagsaing ng kanin, talagang hilaw po Bakit ipipilit natin? Ang alternative lang po, Mr. President, gawin po natin na tama. Iluto po natin ng tama para hindi tayo magkahirap-hirap dito. Isip-isipin po ninyo, sinasabi ng ating Constitution, isa lamang pong impeachment proceedings ang pwedeng i-initiate sa isang opisyal ng gobyerno at hindi po pwede ang 2 beses sa loob ng 1 taon. 4 na beses po ang ginawa nila. At kunwari, in-archive po yung 3 para lamang palitawin na 1 lang ang nabuhay. Nasaan naman po yung katuwiran? Kung sarili pong tuntunin, ayaw pong sagutin, ayaw pong talimahin, pagkatapos ipipilit po natin, sapagkat nag-MR sila, ano po ang kasaysayan ng MR? Sabi ko nga po, napakasimple po nung 1-year ban rule ng Supreme Court. And the Supreme Court is not even obligated and expected to conduct a microscopic, a forensic and scientific scrutiny of this provision where the pertinent language and the relevant meaning is as clear as daylight, Mr. President. Ano po yung gagawin? Hihintayin po ba natin kung ano ang magiging kalalabasan po ng MR na sa akin pong palagay, hindi po speculation, sabi ko nga po. Unanimous decision and bank decision ab initio unconstitutional, violative of due process, immediately executory. Sino po kaya kahit isa man lang na miyembro ng Korte Suprema ang magtatangka na i-reverse niya yung sarili niya? Yun po yung speculation dito. Ngayon, nakikinig po ang taong bayan, Mr. President. Nakadepende po ba ang action natin? Doon po ba nakahang ang gagawin natin sa isang motion for reconsideration na sa aking palagay, matibay po ang aking palagay sapagkat this is borne out by my experience of more than 20 years of legal practice, Mr. President. Yang ibig lang sabihin nung immediately executory, sige, pwede kang mag-file ng MR. But you are wishing for the moon. Sumusuntok ka sa hangin. Yun po ba ang basihan natin? Kaya hindi tayo makapag-desisyon, Mr. President? Sana mayroong mas matibay sanang desisyon. Meron sanang mas matibay na katuwiran. Hindi yung pong nakasalig po sa hangin. Nakasalig po kung puputok ang bulkan o hindi. Hindi po yata gano'n. Ang gawain ng Senado, Mr. President. Tinangka ko na nga pong i-amend. Kung ayaw po ninyo yung motion to dismiss any other language that will put to rest this issue in obedience and in complete respect to the last word of the Supreme Court, it being immediately executory, Mr. President.
What is the pleasure of Senator Aquino? I saw him raising his hand earlier. Senator Aquino seems to be yielding to
Yes,
Senator...
Mr. President, may we recognize Senator Lacson, Mr. President?
Thank you, Mr.
With the
President.
permission of Senator Aquino, Senator Lacson is recognized.
Thank you, Mr. President. Gusto ko lamang pong itama ang misimpression that may have been created by the interpretation of the Honorable Marcoleta do sa Section 135. Sabi niya, yung suppletory application of the rules of court. Basahin ko po yung Section 135, Mr. President. If there is no rule applicable to a specific case, the presidents of the Legislative Department of the Philippines shall be resorted to. And as supplement to this, the rules contained in Jefferson's Manual, Riddick's Precedents and Practices, and Hinds' Precedents. Wala naman po ako nakita doon sa enumeration na rules of court. Di ba po sabi ng mga abogado, di ba yung expressio unius est exclusio alterius. What is expressly included excludes all others. So wala naman pong rules of court. Kaya gusto ko pong itama yung medyo hilaw pong interpretation ng ating Honorable Marcoleta. Maraming salamat po, Mr. President.
Noted.
Mr. President, may we recognize Senator Bam Aquino has been waiting for his turn to interpolate the gentleman from Tarlac.
Senator
So moved,
Aquino
Mr.
is
President.
recognized and may proceed.
Maraming
Should
salamat.
the gentleman allow it.
Maraming salamat, Mr. President. This is a manifestation, not an interpolation, Mr. President. At kanina pa ako nakikinig.
The gentleman may proceed.
Marami po sa mga puntong nabanggit na ng mga kapwa nating senador ay sumasang-ayon po tayo at tama, no? Napag-usapan na po ang independence ng Senado, kung gaano kahalaga ang papel na ginagampanan natin sa ating bansa, sa checks and balances ng ating gobyerno. At alam rin naman po ng mga kasama natin na sa caucus, sinabi ko rin po na ang posisyon ko ay dapat mag-convene ang impeachment court at doon magdesisyon kung ano ang mga susunod na hakbang pagdating po sa impeachment case. No? That's known to everyone. I've said that in the media. Mr. President, in our history, nagkaroon po ng mga panahon na ang Senado ay nag-assert ng kanyang independence bilang isang co-equal branch of government. Nangyari po yan many times. I remember in the 90s, kahit po ang executive, at that time, President Cory Aquino nagnais na manatili ang US bases dito sa ating bansa. Yung Senado, nanindigan. Kahit puro kaalyado, kahit puro kakampi at kamag-anak nasa Senado, nag-decide pa rin yung Senate to assert its independence and to do away with the US bases. Nangyari po yan many times in our history, Mr. President. Kaya palagay ko, yung role ng Senado napakahalaga pagdating sa pagpapanatili ng checks and balances. And Mr. President, marami tayong tungkulin. May tungkulin gumawa ng batas, may tungkulin sa pagbuo ng maayos na budget, may tungkulin ng oversight, pero meron din pong tungkulin pagdating sa pananagutan or accountability. At yun po yung sole power to try and decide all cases of impeachment. Ang posisyon ko, Mr. President, at nabanggit rin ito ng iba nating mga kasama, ay mahalagang i-assert natin ang ating independence. Mahalaga po na itong papel na ginagampanan natin sa ating Constitution ay pahalagahan po natin. Mahalaga po na manatili ang independence ng ating Senado bilang isang co-equal branch of government. Mr. President, posisyon ko rin po na nagsimula na ang impeachment proceedings. Nag-robe na po, nagsimula na, merong summons na binigay, may response na po si Vice President Sara. Kami pong mga bago, may mga robe na rin po pero hindi pa po nadudumihan. Hindi po magagamit, no? Ang posisyon ko po, mag-convene ang impeachment court at doon natin i-decide ang mga bagay-bagay na ito. Mr. President, may dalawang bagay rin na nailabas, no? Na hindi pa siguro na pag-uusapan. Let me read, Mr. President, Article 9, Section 3 of our Constitution, Accountability of Public Officers. In case the verified complaint or resolution of impeachment is filed by at least one-third of all members of the House, the same shall constitute the articles of impeachment and trial by the Senate shall forthwith proceed. Wala pong dagdag po dito. No? Dito po sa gallery, kasama ho natin dalawang framers of our Constitution. Nandito po si Professor Ed Garcia at si former Chairperson Christian Munsod. Kanina po, nagbubulungan kami. Sabi ko, nung ginawa nyo to, bakit parang ganun kasimple? Simpleng-simple lang, ito lang. At sabi nga po nila, noon daw, 1/2, 2/3, binabato 1/2 sa deliberation, nag-end up sa 1/3. At yung desisyon ay dahil sa kabilisan. Dahil mahalaga daw na mabilis. Pag may 1/3, members of the House ang pipirma, mabilis na pupunta po sa Senado. At ito po, tinatanong ko sa kanila, dahil sila po yung nagbuo ng ating Constitution. You know, many times, Mr. President, umiikot tayo sa ating bansa. I-bring up ko lang po yung free college law. No? Marami ko sa atin dito nagtulungan para sa batas na yan. Meron kaming nakausap na eskwelahan. Ini-explain sa akin yung opt-out provision. Kung paano sila nag-charge ng mga estudyante dahil sa opt-out provision. At sabi ko sa kanila, mali. Mali ang interpretasyon ninyo. Yung interpretasyon ninyo, wala yan sa aming intensyon. Ang intensyon po namin, libre ang kolehiyo sa mga kabataan. At nung nag-argumento po sa akin, ang sabi ko, mas alam ko yan kasi ako ang nagbuo ng batas na yan. Mas alam namin yan dahil kami ang nagsulat ng provision na yan. In the same sense, Mr. President, the framers of our Constitution, mas alam po nila. Mas alam nila kung ano yung intent ng ating Constitution. Wala pong labis, walang dagdag. Many times, Mr. President, tinatanong tayo, usually pag campaign time to, tinatanong kami, Mr. Senator, hindi ba dapat merong educational attainment requirement yung pagiging senador? At sinasabi ko po lagi, wala, kasi wala po yan sa ating konstitusyon. Wala pong dinagdag, wag tayong magdagdag nang wala pong nakasaad po dyan. So gaya po niya, no, binabanggit ko lang po dito dahil na pag-uusapan, may mga dinagdag na mga procedure. Alam ko po, siguro, tama po ang sinasabi ni Senator Marcoleta, baka maganda naman ang intensyon ng Supreme Court. Pero aminin na po natin, wala po yung ibang mga bagay dyan dito po sa ating konstitusyon. Pangalawang punto, ito po hindi rin po nagpag-uusapan pa. Nabanggit po dito, wag na tayong lumaban kasi matatalo rin naman tayo. No? Of course, Mr. President, it is improbable, aaminin ko po yan, very improbable na magbago ang Korte Suprema with 15 votes. But it's not impossible. Improbable at impossible, magkaiba po yan, firstly. But secondly, Mr. President, may mga panahon na kahit alam nating matatalo, kailangan pa ring lumaban. Tayong lahat po dito, dumaan po dyan. Ako po, dumaan rin po dyan. Kahit mukhang mahirap, kahit mukhang matatalo, kailangan lumaban pa rin. Tumayo tayo sa sarili nating paa, mag-assert tayo ng ating independence, ipahiwatig natin yung ating saloobin bilang isang grupo. Ipakita ho natin na co-equal branch of government tayo, na meron tayong punto de vista. At kahit matatalo, kahit sa kaduluduluan ng lahat, rerespetuhan rin naman natin ang Supreme Court, mahalaga na mailagay pa rin kung ano ang nasa saloobin ng ating grupo. Mahalaga pa rin na malagay natin kung ano talaga ang posisyon ng Senado pagdating sa ating independent nature and being the sole authority to try and decide impeachment cases, kahit po matatalo. So para sa akin po, hindi katanggap-tanggap ang posisyon na dahil matatalo rin tayo, huwag na tayong lumaban. Paminsan-minsan po mahalaga na ilagay naman natin ang ating posisyon kahit alam po natin na hindi pabor sa atin ang mga bagay-bagay. Thank you, Mr. President, and we'd like to thank Senator Marcoleta for his time.
Thank you, Senator Aquino. Noted and entered into the records. Senator Marcoleta.
Mr. President, I thank Senator Bam for his manifestation. Totoo nga po na yung binasa niya sa Article 11, Section 3, Paragraph 4, na sinasabi nga naman, in case the verified complaint or resolution of impeachment is filed by at least one-third of all the members of the House, the same shall constitute the articles of impeachment and trial by the Senate shall forthwith proceed. Ngunit, Mr. President, this cannot be applied in isolation of Paragraph 8 na nandito rin po sa the same Section 3, Article 11. Ang sinasabi po sa Paragraph 8, the Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. Kaya po ang sinusunod ng House dapat yung rules of procedures in impeachment proceedings. Pero kagaya po na sinabi ko, imbes na sundin po nila, sila po yung gumawa nun eh. Eh hindi naman po nila sinunod. Kaya po ang nangyari, pinagsabihin ng Korte Suprema, ganito ang pag-file. Nagbigay nga po ng guidelines. Pangalawa po, yung kanyang sinabi na nakapag-umpisa na po kayo eh. Kanina po kinwalify ko yun before I proceeded in my speech. Sabi ko po, the initial proceedings conducted by the Senate of the 19th Congress were not formally carried over into the Senate of the 20th Congress. Wala po talaga eh. I cannot recall, sabi ko nga, and there is no action taken by this chamber, Mr. President, sapagkat ang alam ko, all these proceedings were already deemed terminated at the expiration of the 19th Congress at noon of June 30, 2025. And they cannot be miraculously bring forth to life in this Congress where both of us now belong because this Congress is of different composition. Yun lamang po ang qualification doon, Mr. President.
Quick rejoinder, Mr. President.
Senator Aquino is recognized.
Yes, Mr. President. Babanggitin ko lang po yung isang na banggit ni my co-gentleman from Tarlac, Senator Marcoleta. Mr. President, may Section 4, may Section 8. Di ba? Ito po ba'y meant to reflect each other or not? Maganda pong matanong yung mga framers of the Constitution. Sila po yung nandoon nung nabuo po ito. At malalaman natin yan kung meron pong oral arguments. Kung ibubukas po ang mga argumento sa publiko, pwede po magsalita yung framers of the Constitution, at doon po sa posisyong yon, malalaman natin ano ba talaga ang intensyon ng mga gumawa ng ating Constitution. And Mr. President, pwede pong mangyari yon if we are able to table this matter and allow for these oral arguments to happen. Mr. President, hindi po ba maganda rin kung ang Senado mismo magsama-sama at magsabi sa Supreme Court, baka magandang magkaroon ng oral arguments dito po sa kasong ito. Yun lang po, Mr. President. Thank you.
So we can continue, Mr. President, with the list of senators wanting to interpolate and make a manifestation. At this juncture, Mr. President, may we recognize the distinguished gentleman from Isabela and Davao, Senator Rafi Tulfo, for his manifestation. So move, Mr.
Senator
President.
Tulfo is recognized for his manifestation.
Thank you, Mr. President. This is not an interpellation, but a short, very short manifestation. In line with what Senator Pia Cayetano said earlier, that we can be creative in our motion today, and correct me if I'm wrong, if I've heard it right, what Senator Pangilinan from the minority said, that we are not defying the decision of the Supreme Court. So may I propose that instead of dismissal, we just dissolve this impeachment court? Because in the first place, per the decision of the Supreme Court, sinasabi na wala naman talaga tayong jurisdiction over dito sa Articles of Impeachment. So mas maganda siguro, i-dissolve na lang natin to para we're still in line with what the Supreme Court said. Thank you, Mr. President.
Noted and entered into the records.
Mr. President,
Majority Leader.
next and last but not the least to interpolate the distinguished gentleman from Tarlac is the lady from Taguig and Pateros, no other than Senator Pia Cayetano. I move that she be recognized, Mr. President.
Senator Pia Cayetano is recognized for interjections and/or manifestation. You may proceed, ma'am, if the gentleman will so allow it.
Yes, Mr. President.
Thank you, Mr. President. With the permission of the proponent, Senator Marcoleta, I would like to
Yes, Mr. President.
make a few observations and then perhaps ask His Honor's opinion on these matters.
Please.
Thank you. So, Mr. President, I'm reading directly from the case Duterte versus House of Representatives. Page 95. It states, the subsequent filing of the Articles of Impeachment under Article 11, Section 3.4 against Vice President Sara Duterte and its transmittal by the House of Representatives to the Senate of the 19th Congress is considered to be a separate and distinct mode of initiating the impeachment process. The Articles of Impeachment are declared barred by Article 11, Section 3.5 of the Constitution. Likewise, they are unconstitutional and are deemed null and void ab initio. Consequently, the Senate did not acquire jurisdiction to constitute itself into an impeachment court. This decision is immediately executory. It shall be deemed served on petitioner and release upon publication in the Supreme Court website and receipt of the parties of their digital copy in accordance with AM number 250516 SC or the guidelines on the transition to electronic filing in the Supreme Court. So, I read this into the record, Mr. President, because I'd like to emphasize a few key phrases. The Senate did not acquire jurisdiction to constitute itself into an impeachment court. I'll start with that one, and then the second one is this decision is immediately executory. So, pag sinabing the Senate did not acquire jurisdiction to constitute itself into an impeachment court, and yet the fact remains that we did constitute ourselves into an impeachment court, then what are we supposed to do? Because the Supreme Court tells us that we did not acquire jurisdiction. As most lawyers, well, all lawyers should know, when the Supreme Court tells another body, usually it's the lower court or sometimes it's a government agency, and the case was by our accepted rules elevated to the Supreme Court. They tell them you have no jurisdiction. The only thing you do is, what do they call it? There's a term, you have residual powers. And those residual powers basically simply allow you to dispose of the case as per instructions of the Supreme Court. Is that the understanding of His Honor?
Yes, Mr. President. Actually, residual powers apply also under Section 135. Yun po yung sinasabi ko kanina. Hindi ko po sinabi kanina na I am invoking that because the rules of court are there. Hindi po yun. Kasi legislative department po ang sinabi ko doon. Kasi wala pong applicable rules. Pwede po yun, ma'am, Mr. President.
Kasi ang akin po, and I've tried all my life to be a dutiful citizen, and Alan knows I was a good daughter, a better daughter than he was a son, in terms of following our father's rules. Pag sinabing, hindi mo pwedeng gawin yan, wala kang karapatan na gawin yan, hindi ko gagawin yon. At kung ginawa ko yon, babawiin ko. Kasi nga sinabi sa akin na wala akong karapatan na gawin yon. So, yun ho ang iniintindi ko. I am one of 5, tama bang bilang ko, 5 lawyers here in the Senate. And I'm trying to do my job as a senator and as a lawyer. I am trying to listen carefully to our colleagues who have expressed their desire to constitute ourselves as an impeachment court. But I do not know how we can legally do that when the Supreme Court tells us we did not acquire jurisdiction to constitute ourselves into an impeachment. impeachment court. We did not acquire it then, and we do not acquire it now. So how would we do that? How? And those of you who've worked with me know how hard I work to find a solution. I bend over backwards, I listen, I redraft everything para masaya tayong lahat. And of course, within the bounds of the law. How do we do that? How?
Mr. President, I think the good senator already provided the answer. By using the Senate's residual power, kung titignan po niyo yung definition ng residual power, hindi po talaga nakasulat yung power per se. Ngunit inherent sa opisina yon, kaya tinawag pong residual power. Nung sabihin po ng Korte Suprema, this is immediately executory, wala pong ibang departamento, walang ibang opisina ang tinitingnan niya kundi tayo lamang. Kung hindi tayo gagalaw, wala pong iba na gagalaw. At mananatili pong nakahang ang isyong ito, Mr. President.
So yun yung first point, Mr. President, that I wanted to raise, and thank you for your response, Senator from Tarlac. And then with respect to the second phrase that I wanted to dive into, immediately executory. So sinabi to dun sa desisyon, and then I think the Senate President mentioned it also, that in their press briefing just yesterday, the Supreme Court stated that, to recall, on July 25, 2025, the Supreme Court granted the petition to dismiss the fourth impeachment complaint against Vice President Duterte. In a 13-02 decision with the justices present voting unanimously, and Associate Alfred Benjamin Kagiwa inhibiting, and Associate Justice Maria Filomena Singh on leave, the Supreme Court en banc ruled that the impeachment complaint was void for violating the one-year ban and due process requirements. This decision is immediately executory. Inulit pa nila sa press briefing nila. So sa akin lang po, parang nahihirapan ako as a lawyer and a lawyer in the Senate to say that they did not intend it to be immediately executory, because they said this knowing that there already was a motion for recon, and knowing that we are going to have this discussion today, because we made this date public, that on this day we will have this discussion. So again, I'm trying hard to see how, other than disposing of the case using our residual powers following the instructions of the Supreme Court, we can further debate this issue. That is my dilemma, dear colleagues, Mr. President.
May I offer an answer, Mr. President?
Of course.
Pasensya na po kayo kung gagamit po ako ng paghahalimbawa. Nung pong kayo po ay medyo bata-bata po, Madam Senator, meron pong lumigaw sigurado sa inyo. Yung
Huwag
unang
na ho
lumigaw
natin
sa inyo
pasukin
talagang...
yung diskusyon na yon. Mahaba ho ito, mas mahaba po sa debate ng impeachment.
Ganito po yun eh. Tinapat nyo talaga. Ayaw nyo magtagal pa yun eh. At tama naman po yung ginawa ninyo. Ipinakita nyo sa kanya, pinaramdam nyo sa kanya, talagang wala siyang maasahan. Kesa mapagod pa siya.
Sino ho
Pero ang
yun?
sabi niya sa inyo, ang sabi po niya sa inyo, pwede bang ako'y kahit papaano'y dadalaw-dalaw pa rin? Parang nag-MR. Nasa sayo yun, but that will not change my mind. Ganon din po yun eh. Ang Korte Suprema, sa ganitong, Mr. President, the very tenor of the decision, kahit na po sinabi niyang, oh sige, nasa sayo, formality na lamang po yun, Mr. President. You are a trial lawyer too. Most of us here became trial lawyers. This is our experience. Huwag po nating pahirapan yun. Sana man lang kung ang decision po 8-7. Yun po pwede nating pagtalunan po eh. Wala po talaga eh, Mr. President.
If I may, Mr. President, and I think that was a good analogy. Thank you for that. Napaisip niyo ho ako doon. I think what's interesting with His Honor's analogy is there are people, there's the public, I don't know, millions of people would like to understand ano ba yung final na kasong yon, may evidence ba? And totoo yan, di ba? Hindi natin matatanggal yon. So in the same way, the yung manliligaw na walang pag-asa, gusto din niyang malaman na ano ba yung chances, ano ba yung nangyari, bakit ba meron kang ganitong conclusion, can I convince you otherwise? I think that's what His Honor is trying to say. And I think the public really want to know. Let the record show na tawang-tawa po si Senator Bato sa likod. But we really want to know, sino ba namang may ayaw malaman kung merong isang public official na naakusahan ng katiwalian? Lahat po tayo interesado doon whether mahal mo yung taong yon, whether galit ka sa taong yon, you want to know the truth. Kasi kung naniniwala ka na innocent yung taong yon, gusto mong mapatunayan niya na innocent siya. At kung galit ka sa taong yon, gusto mong mapatunayan na guilty siya, hindi ba? But meron tayong kinikilalang Supreme Court na nagsasabing hindi nga dumaan sa tamang proseso. So kumbaga siguro sa example nyo, baka hindi dumaan sa tatay ko, hindi nagpaalam ng maayos. Di wala naman akong choice, kundi sabihin na wala kang pag-asa. Baka naman may pag-asa, pero I have to follow the rules of my father's house na hindi dumaan sa tamang proseso. So doon ho tayo babalik, and as a lawyer, I have to say this na yun nga, we are governed by laws. And in as much as gusto ko rin malaman, bothered ho ako sa mga gantong akusasyon. The other day, our colleagues, merong privileged speech tungkol sa kalokohan dun sa paggagawa ng mga flood control. Gusto natin malaman, di ba? Ngayon, pagka yun na-discuss sa sa media, okay na, media siya. Pero walang papupuntahan yun kasi it should go to the proper process. May process yan sa halls of the Senate. We have hearings in aid of legislation, and then magre-recommend tayo na ma-ombudsman yan. So may proseso tayo. So yun ho siguro yung pinapatunguhan. Doon ho papunta ang aking conclusion na in as much as the public deserves to know, because we all deserve to know, we also have to follow the process. And I share this with everyone kasi ang hirap lang talaga ng sitwasyon natin kung hindi tayo makikinig sa Supreme Court. Meron tayo in the Senate, Congress, we have our duties as co-equal bodies. Ang duties po namin kasama ang pagsiyasat ng budget ng lahat ng agency. So pati Supreme Court, budget niya, tinitingnan. Lahat ng Regional Trial Court, tinitingnan natin ang budget. That's our job as a co-equal. Sila naman, may job din sila na pagka may grave abuse of discretion, they have to also say it. They also have to make their position known, which they have. And I will repeat, ang sabi ng desisyon ng Korte Suprema, the Senate did not acquire jurisdiction, and this decision is immediately executory. So, I'm happy to listen. I don't know kung may magsasalita pa, pero I shared my views on this in the hope na marinig ko din yung views ng proponent. Nakikinig po ako sa mga kasamahan natin para ma-enlighten din po ako. But I'm guided also by my practice as a lawyer and my duty as a lawyer to also, I can disagree with the court. Wala tayong problema doon. We know that we have that personal right to disagree with the court, but we also have to, in the end, follow the court's orders, whether we agree with them or not.
Very quickly,
Thank you, Mr. President.
With the permission of Senators Marcoleta and...
What is the pleasure of Senator Pangilinan?
Just a quick interjection.
The gentleman may proceed.
Maybe to add to either the enlightenment or additional bewilderment of Senator Pia Cayetano. Yes, the Supreme Court ruled that we did not have jurisdiction. Yes, the Supreme Court ruled that it is immediately executory, but it makes you wonder why the Supreme Court did not issue a writ of injunction. So
Did not, sorry, I didn't hear that. It makes you wonder why.
Did not enjoin us, did not issue a writ. It could have, but it did not. So, yeah, your guess is as good as mine, because if they really wanted us to end this, then why didn't they enjoin us?
Just to add to the bewilderment and the enlightenment, what is there to enjoin when we never acquired jurisdiction according to them? What is the pleasure of the Honorable Ontiveros?
Thank you, Mr. President. Dalawang dagdag na punto lang para sa diskusyon natin. Precisely regarding the immediately executory na kababanggit lang ni Senator Pangilinan at inulit din kanina ng good gentleman from Tarlac at pati ng good gentlewoman from Taguig Pateros, immediately executory. Still, Mr. President, there is no defiance here dahil the ruling, hindi pa rin po final siya. And even if the ruling states that it is immediately executory at kahit inulit po yon dun sa recent na anunsyo ng Korte Suprema tungkol sa MR, even if the ruling states that it is immediately executory, the court itself in many cases has explained that this does not mean self-executory. Immediately executory does not mean self-executory. Section 1, at ito taugnay ng kasasabi ni Senator Pangilinan, Section 1, Rule 39 of the 2019 Rules of Court states that execution shall issue as a matter of right on motion. This means that a writ of execution issued upon a motion is necessary for the execution of a decision. At this point, Mr. President, wala pa pong iniuutos ang Korte Suprema sa Senado. And secondly, at this point, Mr. President, bukod pa po kasi sa yung first group of complainants, yung House of Representatives mismo sa pamamagitan ng Solicitor General at yung isang bayan, meron pang isang importanteng entity, institusyon sa ating lipunan na nagsalita tungkol doon sa Supreme Court ruling. At ito po ay isang entity sa mass media, ang ABS-CBN. Meron po silang anunsyo, ABS-CBN news statement on articles cited in the Supreme Court decision on Vice President Sara Duterte's impeachment. At gusto ko lang i-make of record dito, Mr. President. Sabi nila, ABS-CBN News respectfully clarifies that the article cited in the Supreme Court decision on the impeachment of Vice President Sara Duterte did not state that the House of Representatives transmitted the articles of impeachment to the Senate without a plenary vote. The ABS-CBN statement, Mr. President, calls into question the factual premises of the SC decision. Isa po ito sa binabanggit na numerous factual errors. If the very factual premises were wrong, the legal conclusion cannot be relied upon. With due respect, salamat po, Mr. President.
Majority Floor Leader.
Yes, Mr. President, last but not the least is a quick manifestation from the distinguished gentleman from Palawan, Senator Erwin Tulfo. I move that he be recognized, Mr. President.
Senator Erwin Tulfo is recognized. You may proceed, sir, if the gentleman will so yield.
Yes, Mr. President.
Ginoong Pangulo, bilang bagong senador, ako po ay nais ko pong maliwanagan dahil kanina pa po ako nagugulamihanan sa mga pangyayari. Dahil 3 motion po ang nakasala ngayon, motion to dismiss, motion to table, motion to archive. Yung pagkaintindi ko po ngayong araw, 2 lang po ang ating pagdidesisyonan. Kung tayo ay i-dismiss na natin ito, o tayo po ay magkakaroon ng trial. At nag-aantay po ang taong bayan. At lumalalim na po ang gabi. Kaya ang tanong ko po ngayon, are we actually going to vote later or sa ilang saglit? At ano po ang ating pagbobotohan, Ginoong Pangulo? Yan lamang po.
To answer the query of the good gentleman, there are only 2 pending motions. The motion to table by the distinguished Minority Floor Leader, which has precedence over the earlier motion of Senator Marcoleta, supposedly to dismiss, but that he acceded to amend it accordingly, and he will state the motion before we put it to a vote after we dispose of the motion of the Minority Floor Leader to table. So dalawa lang po yung pagbobotohan at dahil sabi ng kagalang-galang ng puno mayoriya na kayo na po yung huling magmamanifest, tutungo na po tayo doon.
Maraming salamat po.
With that, Mr. President, and no member wishes to interpolate, the minority leader is also seeking the floor. I move that
The
he be
minority
recognized, Mr.
leader is
President.
recognized. What is your pleasure, sir?
Thank you, Mr. President. Just one last push, so to speak.
The gentleman may proceed.
We're not saying that we defy the Supreme Court decision. We're simply saying, wait. Patience is a virtue. Yung analogy kasi na sa panliligaw, dismiss mo na kagad. Although merong mga matintimang birheng bumigay. Mas magandang analogy ito, Mr. President. In a basketball game, crucial, finals, world championship, merong review ng foul ang referee. Review muna. Dahil may foul eh. Ang gusto ng isang team, maglaro pa rin kahit nire-review. It's as simple as that. So, why not listen to the possibility of not dismissing but not accepting to table. And then we can bring it out anytime. Again, dun sa sinasabing Supreme Court has never considered a unanimous. It has. And the Supreme Court also spoke. Sabi nila, the immediately executory, they are not considered final until the lapse of the prescribed period without a so and so and so. Supreme Court din mismo may sabi niyan eh. Yun lamang po. Hopefully, kung speculation na pinag-uusapan natin, stating that the Supreme Court will not reverse its unanimous decision is also speculative. So, pagbigyan natin to, Mr. President, sunod tayo, pero ilagay naman natin sa lugar. Medyo, ang Senado naman dapat itaas natin ang integridad, reputasyon. Hindi tayo, pag sinabing tumalon, tatalon. Pakinggan naman natin muna dahil maraming mali Maraming error ang House, may error din yung Supreme Court decision, obviously. So you cannot right a wrong by another wrong. Thank you, Mr. President.
Noted. Senator Allen.
Mr. President.
Mr. President. Mr. President.
Yes, Mr. President.
So, I'm discussing with the minority leader, trying to pursue a wording that will articulate our collective intent of the Senate. May I just mention and have a few, maybe 2 minutes with what Senator Risa, the esteemed senator, said. Yung spirit kasi ng Constitution, once ka lang pwede ma-impeach sa 1 taon. At very clear po, pati po yung esteemed, I do recognize our the former chairman of the COMELEC, who, if he did not qualify me, I would not have become a councilor. Christian Munsod, our esteemed legal luminaries are here po. Alam niyo po, in all the books nakalagay doon, bakit may 1-year ban? Kasi nga, hindi daw dapat guluhin ng guluhin yung impeachable officer all throughout the year. Dapat isa lang. So yung spirit ng decision, nung sinabi ng BARD na, bigyan mo siya hanggang 1 year, hanggang February 6. Pero lumabas tayo sa legal. Ipa-floating muna natin to. I-dribble muna natin. Tignan muna natin. When is the soonest that the Supreme Court can decide? The next 15, 30 days? By September 1, simula na ng budget hearing sa House. By late September, simula na tayo sa Senate. Baha, DepEd, gamot, trabaho, lahat yan, inaasikaso natin. Kung walang choice at isasabay natin impeachment hapon, impeachment umaga, legislation, bakit hindi? Pero hindi ba dapat bigyan din natin ng katahimikan yung ating bansa at least until February 6? Na sinabi na ng Supreme Court, barred, mali ang proseso, tuldukan na rin natin sa Senado. So, ang isa na lang po ang pinag-uusapan natin, which I want to give honor and thank the minority leader na, pero may appeal. So, whether or not the Senate says tuldukan na natin, nandun pa rin sa Supreme Court yung appeal. Would it be acceptable both to Senator Marcoleta and to the minority? What if we word the motion that we move to adhere to the decision of the Supreme Court in Duterte versus period? Huwag na natin ilagay sa dulo kung dismiss, area. Merely adhering. Kasi nasa decision naman, nasa loob na naman ng decision na void ab initio and executory right away. So I don't know if that's acceptable. No? I'm trying to think of a word. Adhere, even obey kasi baka ma-misinterpret na because some of us say na wala tayong choice to obey, some think na wag tayo subservient, di ba? But adhere might be a good word. Senator Marcoleta, are we getting closer or medyo lumayo?
I think, Mr. President, we're getting closer, except that we should put some operative words there that would indicate the closure of this very issue.
Mr. President, what if it's we move to for the Senate to adhere to the Senate to the Supreme Court decision in Duterte versus House of Representatives and hereby terminate whatever unless or until certain time na may Mr. President, may I ask the good sponsor, can we mention the appeal?
I don't think so, Mr. President. Yes. I think we can only
because
adhere.
It's immediately executory.
I think in obedience to the decision of the Supreme Court, the Senate adheres to it and put to rest.
Let me put it another way, Mr. President. If a motion is approved to act upon the decision and to adhere to the decision, am I correct, Mr. President, that that will be the decision, that will be in our journal, and then by operation of administrative process in the Senate, everything that has to do with the impeachment will be sent to the archives?
That is correct, Your Honor. That is the
I yield to
administrative procedure
Yes.
that will logically follow.
I yield to my colleagues, Mr. President. I'm just trying to
Senator
come up
Zubiri
with a
is
consensus.
Mr. President, I think the operative word today, if we do decide to act on the matters, to archive, as the precedents with former Ombudsman Gutierrez and former Chief Justice Davide. My question is,
Former President Estrada.
former President Estrada, my apologies. Today, one of our Senate resolutions was archived. This is resolution number 35. And it's really simple, a simple amendment to the rules. But my question, Mr. President, is nothing can stop us from pulling it out of the archives and taking it over once again in plenary. Is that correct, Mr. President?
That is correct, Your Honor. Besides, although the Supreme Court said that the Senate never acquired jurisdiction and that the articles of impeachment are void, null and void ab initio from the beginning, we cannot deny the fact that the articles of impeachment were in fact sent to the Senate, that the Senate convened and sent out certain orders and summons, and these are all part of the records. So it's but natural, although it was declared unconstitutional and that the Senate never acquired jurisdiction, for us to still include that as part of the records of the Senate, because it is part of the Senate's history.
Yes, and precedence tells us that we have done so in the past.
That is correct, Your Honor.
So, would it be proper to say that it will be archived without prejudice to the decision from the final decision of the Supreme Court from the motion for reconsideration? I mean, it's the same thing, without prejudice.
we do that with the bills. We approve it on second reading without prejudice. But each and every one of us here questioning second reading approval, they have 3 days in which we can act upon it.
Well, Your Honor, whether you state that or not, we can bring it out of the archives by a majority vote anyway. So it's at the
Yes.
pleasure. It's with the pleasure of the body if
Yes.
the body will agree to include that phrase or not. But
Thank you
in
for the
relation to
clarity,
Senator
Mr. President.
Cayetano's suggestion, Senator Marcoleta, if we simply vote in your case, not the motion to table, to adhere, once that decision becomes final, meaning to say after the lapse of the period for a member who voted with the winning side, on the winning side, to seek a reconsideration, the natural effect, without being included in your motion today, would be to archive it. And by virtue of the manifestation of former Senate President Zubiri, if circumstances change, nothing prevents the body, plenary, from making the corresponding motion, putting it to a vote, and reflect the change in circumstances, if any.
That will be acceptable, Mr. President.
Thank you, Your Honor. Senator Soto?
Mr. President, somehow parallel to what you're discussing, perhaps we could consider, no, and I would like to call the attention of the original proponent of this position, Senator Alan Cayetano, who was former Speaker of the House, to adhere to the Supreme Court decision upon its final disposition. In meantime, table or archive upon whatever your pleasure would be. At least, maliwanag sa atin na upon its final disposition, na may motion for reconsideration. We're still giving that chance of a motion for reconsideration.
If I may, Your Honor, if you will indulge me, if I may state the working motion to adhere to the July 25, 2025 decision of the Supreme Court declaring the Articles of Impeachment null and void ab initio, and that the Senate did not acquire jurisdiction over the same. We can stop there. And then, as I said, after the vote becomes final, on Monday or Tuesday, if no one will seek a reconsideration, to archive it. If there is no change, then it remains in the archives and nothing needs to be done. If the Supreme Court reverses itself, however possible or impossible that may be, then we will entertain a motion to bring it out of the archives. Bring it out of the archives and act accordingly again in obedience to the Supreme Court decision. So,
ang problema, Mr. President, when we say that the Senate has not acquired jurisdiction, masang-ayon tayo sa sinasabi ng Supreme Court decision nilang ito na maraming nagsasabi na hindi tama. Dahil tinawag nyo to ng June 9 nag-oath ang Senate President. Nag-oath yung iba ng June 10, nag-motion, nag-robe pa nga Hindi naman pwedeng pampelikula lang yun, pan-TV lang yung robe na yun. You convened. So hindi pwedeng sabihin ng Supreme Court that you never acquired jurisdiction. February 5, 4:15 p.m., the Senate President's Office and the Senate Secretary has received the Articles of Impeachment.
I'm sorry, Minority Leader. Legally, when you say the Senate never acquired jurisdiction, it does not deny the fact that we convened. That is a totally different matter. It says that since the Articles of Impeachment violated the one-year ban, that we never supposedly acquired jurisdiction. Not that we never did when it was not yet barred by the Supreme Court. That factual situation still exists and is part of our records. As I said, that's why the better alternative is to archive it, because it was part of what actually happened, transpired, and it's part of the Senate's history. But having said that, without belaboring the point, if agreement cannot be reached, then we can proceed to dispose of the motion of Senator Soto, our distinguished Minority Floor Leader, to lay the motion of Senator Marcoleta on the table, and depending on the outcome of that vote, should it not be favorable to the movant, then we proceed to act on the motion of Senator Marcoleta. If it is favorable to the movant, the distinguished Minority Floor Leader, then there is no need to proceed with the motion of Senator Marcoleta. Senator Lacson.
Mr. President, we have to determine first if Senator Marcoleta has legal standing in filing his motion to dismiss.
He will amend this motion later. We will first decide on the motion.
So
to
there's
the table.
amendment to the motion.
Yes, and then
Thank you, Mr. President.
let's hear his motion, Your Honor.
Yes. Mr. President, the lady from Antique is seeking the floor. I move that he be
Senator
she be
Duterte
recognized,
is
Mr.
recognized. What is your pleasure, ma'am?
Thank you, Mr. President. It's been 3 hours and a half with the very enlightening discussions. I just wanted to clarify, and actually, may I convey that there is a sliver of a difference between the two motions, so I wanted to be clarified. The original motion to dismiss, I believe, has been amended based on the discussions to the motion to archive.
Yes.
And the motion to archive, in my understanding, based on all the explanations, would be without prejudice to the reopening of the possibility after the Supreme Court conveys its ruling on the motion for reconsideration.
Yes.
And therefore, in the possibility of the event that it reverses itself, then we would act accordingly.
That is correct. Yes.
On the other hand, there is a motion which takes precedence, and that has been the motion of the Minority Leader to lay on the table the motion. But when you see and interpret the amended motion of the original movement, Senator Marcoleta, and the Minority Leader's motion, it's similar because it lays on the table, or it somehow just postpones indefinitely until such time that the Supreme Court has decided on the motion for reconsideration. Is there any possibility that
May I
we can
explain the
agree so that we can amend it so that the body can actually vote as one? Because we are not putting it to a permanent halt, because we will be waiting anyway for the motion for reconsideration by the Supreme Court.
Yes, Mr. President.
The ruling on that.
May I have
Yes.
1 minute to explain the difference?
I know that there is,
Yeah.
let me state, I know there is a difference. I was just trying to bridge
Yes.
the difference so that there is no need for a painful vote.
Yes, I will just explain the
yes.
difference so that we
Senator
know.
Cayetano is
Yes.
recognized with the permission
Yes.
of Senator Rintulfo.
Thank you. Mr. President, the reason why I want to explain the difference, para malaman natin bakit malapit pero malayo.
Yes, okay.
Because when you laid it on the table, ang ibig sabihin niyan, buhay pa yung impeachment. Samantalang sinabi ng Supreme Court, immediately executory. So pag lay on the table, buhay pa yan, pero mamamatay yan paglabas ng MR. Pag in-archive mo, baliktad. Patay na yan. Kasi sinabi na ng Supreme Court, immediately executory.
Void ab initio.
Pero mabubuhay yan pag binuhay ng Supreme Court. Now, ang ibinigay na po ni Senator Marcoleta sa atin, pumayag na siyang tanggalin yung word na dismiss. Because nga, even I question, we're going to dismiss, wala nga jurisdiction. Although there's a Supreme Court ruling saying na pag wala ka na magawa, walang jurisdiction, i-dismiss. So the proposal, which is accepted by Senator Marcoleta, is that we adhere to the decision and then archive it. So ang natural effect nun, sinunod natin yung Supreme Court na immediately executory. Wala tayong, we cannot say na tama to, malito. You only have 2 choices. Do you follow the Supreme Court or you don't follow? You cannot say tama to, malito. So I think that's the level of disagreement.
Okay, I
Mr.
take
Chair.
note of that, and I was trying to have a unanimous vote and trying to bridge the 2 motions, which based on Rule 31, there is actually no motion to archive, but actually every day we archive in our referral. So because of that practice, then that motion is therefore acceptable. Having said that, Mr. President, let me just summarize what we are voting on. We're actually, and I will just say it, the very, very short dispositive portion of the Supreme Court decision. And this is the article, and I quote it, the articles of impeachment are declared barred by Article 11, Section 3, Paragraph 5 of the Constitution. Likewise, they are unconstitutional and are deemed null and void ab initio. Consequently, the Senate did not acquire jurisdiction to constitute itself into an impeachment court, and this decision is immediately executory. I just wanted to summarize what we've been discussing for 3 hours and a half. And while my attempt to bridge the two similarly worded motions did not succeed, then we will therefore have to put it into a vote. Thank you, Mr.
Majority
President.
Thank you, Mr. President. Mr. President, I think we heard enough, and I think it's about time that we dispose the motion of our distinguished minority
Mr. President,
leader
Mr.
to lay
President.
this on the table, Mr. President. So
Parliamentary
I move
inquiry.
for the previous
Parliamentary
motion.
inquiry, Mr. President.
What
Mr.
is
President, Senator Aquino is seeking the floor.
What is the parliamentary inquiry of Senator Aquino?
Mr. President, may I get, earlier Senator Cayetano talked about the differences between a motion to table and motion to archive. May I get an official response, Mr. President? Is that really the difference?
Your Honor, we have not yet heard the motion of Senator Marcoleta.
No, Mr. President, a motion to archive and a motion to table, for us laymen, it sounds similar. Sa totoo lang, Mr. President. Anong pinagkaiba niya, Mr. President?
Senator Aquino,
I mean,
what Senator Soto, that's why I prefer that we act on the motion. What Senator Soto is seeking to table is not the articles of impeachment nor the impeachment case, but the motion of Senator Marcoleta, which we haven't heard.
Okay.
So, when we decide on the motion to table, the motion of Senator Marcoleta, not the articles of impeachment.
Yes. And the motion to archive are the articles of impeachment, Mr. President.
Yes.
Yun yung pinagkaiba niya.
Yes.
Thank you, Mr. President.
Senator Soto?
My motion to table was to table the motion of Senator
Senator
Marcoleta.
Marcoleta, yes.
The
That's
motion
exactly
to
what I
dismiss.
said, Your Honor.
Yes.
Oo.
That's exactly what I said.
That is
That
not,
the motion to table pertains to the motion of Senator Marcoleta,
to dismiss.
not
Correct.
the articles of
new one.
impeachment.
Not the articles.
The motion of Senator Marcoleta, if at all, would pertain to the articles of impeachment and or the impeachment case.
And if I may add, Mr. President.
Senator Pangilinan?
Well, the motion to archive,
Senator Pangilinan, we're not yet there.
well, okay, the motion to table, the motion, then frees us from the debate of whether or not we have the power as a Senate in plenary to address the impeachment complaint.
The chair said that earlier.
Yes, and therefore.
We will first put
Okay.
to a vote the motion to table of our distinguished minority floor leader, which under our rules has precedence over the motion of Senator Marcoleta, although made earlier. Depending on the outcome of that vote, then we will act on the motion of Senator Marcoleta accordingly. Senator Estrada.
Mr. President, we have been listening to all the manifestations of almost all senators who stood up. Mr. President, it has been 4 hours listening to several manifestations of our colleagues, and it is about time that we decide right away the pending motions before us. Mr. President, the Filipino people are watching. The Filipino people are listening. The Senate has to act, and the Senate has to act decisively. Thank you, Mr. President.
Thank you, Mr. President. I move for the previous motion, Mr. President. On the motion of the minority leader, Senator Tito Soto, to lay on the table the motion of Senator Rodante Marcoleta.
Is there any objection to the motion of the majority leader for the Senate? What is the pleasure of the minority floor leader?
Mr. President, I move for a nominal vote.
The chair has every intention of doing that, Your Honor. There is a motion to vote on the motion of Senator Soto to lay on the table the motion of Senator Marcoleta pertaining to the articles of impeachment vis-a-vis and in light of the Supreme Court decision of July 25, 2025. To explain, a yes affirmative or aye vote supports the motion of the Honorable Minority Leader, and it therefore means that we will not act on the motion of Senator Marcoleta today. A nay vote, a no vote, means that the motion of Senator Marcoleta will not be laid on the table and that we will act and vote upon it today. Senator Lacson? Later on, we'll know the amendment. Senator Lacson, so that it's on the record, please.
So you're only referring, Mr. President, to the motion to dismiss? No, motion to table. Just the motion to table.
Just the motion to table, Your Honor, because we are not yet there. There being no objection, the motion is of the... Yes, Senator Zubiri.
Yes, Mr. President, being a former Senate President and being former Majority Leader, I'd like to ask the audience to restrain from commenting or laughing, please. Well, we are in a, for me, it's a sacred place. It is in the August chamber of the Senate that we have decorum. May we ask for decorum from those who are watching within the plenary, Mr. President.
Actually, they have been silent for the past 3.5 hours. Chair would like to remind the people in the gallery to kindly respect the processes and procedures of the Senate and to avoid any claps, any jeering or comments so that we can proceed with roll call vote.
Yes, with due respect, because I heard a lot of laughing after the poor gentleman from our good friend, Senator Lacson, asked only for a clarification of the vote that will happen in a few seconds.
The
Yun
Sergeant
lamang
at
po,
Arms is so
just
directed.
proper decorum because this is a very important vote and it's a very serious vote that will be taking place. Thank you.
The Sergeant at Arms is so directed to kindly maintain order in the gallery. Acting now on the motion of the Majority Leader for us to divide the House and vote on the motion to lay on the table, Secretary is directed to call the roll for nominal voting.
Roll call vote. The Honorable Senator Aquino. Senator Cayetano Alan. Senator Cayetano Pia. Senator De La Rosa. Senator Ejercito. Senator Estrada. Senator Gatchalian. Senator Go. Senator Ontiveros. Senator Lacson. Senator Lapid. Senator Legarda. Senator Marcoleta. Senator Marcos. Senator Padilla. Senator Pangilinan. Senator Soto.
May I register my vote, Mr. President?
The Minority Leader may proceed.
Thank you. Mr. President, the Supreme Court decision is now pending appeal. It is prudent to wait for the results rather than prematurely archiving, if not dismissing, because I know for a fact, once it is archived, it is dead. So what happens if the Supreme Court reverses itself? Clear and blatant errors are present in the ruling of the Supreme Court. First, they misunderstood the legislative process in assuming that the 19th Congress adjourned sine die in February 5. Grave error. Thus effectively dismissing the first three complaints, paving the way for them to say na ano pala, yung 1-year ban binayolate. The archiving of the three complaints were done after the initiation of the fourth complaint. The 1-year ban did not set in. Second, the decision practically amended the clear mandate by the Constitution by placing a hierarchy on the modes to initiate an impeachment complaint. Parang wala na yung third option. Third, the Supreme Court retroactively applied the new definition to the present case in the violation of the doctrine of operative facts, thus voiding as well the impeachment proceedings of former President Estrada and Chief Justice Corona. they did not interpret the Constitution, Mr. President. They amended the Constitution. So lastly, the Supreme Court now has the chance to rectify these errors in its decision. So I was hoping to table the motion so that we can let us afford them this opportunity for the benefit of future impeachment processes and to uphold the clear mandate of the 1987 Constitution. All we needed to do was wait a little. And so I will have to register a yes vote. I know it will be a vote in the minority, but I have always voted in the minority in many issues in the Senate since 1992 up to the present. Always prayed I was wrong. Unfortunately, I was always right. My God, have mercy on your decision. I vote yes.
Noted. Secretary will please continue.
Senator Tulfo Erwin, Senator Tulfo Rafi, Senator Villanueva, Senator Villar Camil, Senator Villar Mark, Senator Zubiri, Senate President Escudero.
No.
Pwedeng mag-explain ng boto.
Before the explanations of vote, Chair would first like to make of record the result. With 5 affirmative votes, 19 negative votes, the motion to table the motion of Senator Marcoleta is lost. Lost. Soto. Sorry, Senator Soto is lost. No, he said the motion to table the motion of Senator Marcoleta is lost. Pati tuloy ako, nalito dito siya.
Mr. President,
Senator Villanueva.
if I may, Mr. President, and to go back to the first motion raised by Senator Marcoleta, if I may be allowed, Mr. President, to amend, Mr. President, the motion, Mr. President.
The gentleman may proceed with the permission of Senator Marcoleta.
Mr. President, adhering to the immediately executory decision rendered by the Supreme Court en banc on 25 of July 2025, which held, among others, the Articles of Impeachment are null and void ab initio, and that the Senate did not acquire jurisdiction over the same. I move to transfer the Articles of Impeachment in relation to case number 002-2011 entitled in the matter of the impeachment trial of Vice President Sara Duterte to the archives. I so move, Mr. President.
What does Senator Marcoleta say?
I accept, Mr. President.
There is a motion as enunciated by the minority floor leader. What is the pleasure of Senator Zubiri?
Yes, thank you, Mr. President. Mr. President, instead of a viva voce vote on that motion, may we be allowed to manifest our votes with a short manifestation, Mr. President, each and every one of us. Yeah, through nominal voting, Mr. President, with the permission of the body, of course.
No, I think, Senator Soto, the motion of Senator Zubiri is to conduct nominal voting and allow the members to explain their votes after casting their vote, not after everyone has voted. I think that is the tenor of the motion of Senator Zubiri.
Correct.
Ang binobotohan muna natin, amendment mo di ba? Tinanggap niya.
Hindi, yung motion na.
Tinanggap niya. So, Mr. President, the Majority Leader, Senator Marcoleta accepted the amendment of the Majority Leader. So, what are we voting on now? May we now
The motion as amended by
the motion
Senator
as
Villanueva.
May we hear the motion as amended, please?
May the gentleman,
Yes.
the distinguished majority leader,
Yes,
kindly
Mr.
state
President.
once again for the record and benefit of our colleagues, the motion as duly accepted by Senator Marcoleta.
Thank you, Mr. President. Adhering to the immediately executory decision rendered by the Supreme Court en banc on 25th July 2025, which held, among others, that the articles of impeachment are null and void ab initio and that the Senate did not acquire jurisdiction over the same, I move to transfer the articles of impeachment in relation to case number 002-2011 entitled In the Matter of the Impeachment Trial of Vice President Sara Duterte to the archives. I so move, Mr. President.
May we register, would anyone from the minority or those opposing the motion would like to make of record their objection before so that we can divide the House?
Yes, Mr. President,
Yes,
I
please.
object and
Thank you.
ask for a nominal vote.
Thank you. With the understanding, Senator Soto, that it is in accordance with the request of Senator Zubiri, that upon the name is called, the explanation of vote may be made, should they so desire. There is a motion duly objected to, as stated by the Minority Floor Leader, to place into to transfer to the archives the impeachment articles of impeachment in relation to the impeachment complaint against Vice President Sara Duterte. Secretary is directed to call the roll and proceed to nominal voting.
Roll call vote. The Honorable Senator Aquino. Senator Cayetano Alan.
Sir President, sabi po ng preamble ng Philippine Constitution, we, the sovereign Filipino people, imploring the aid of Almighty God in order to build a just and humane society and establish a government that shall embody our ideals and aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and our posterity the blessing of independence and democracy under the rule of law, a regime of truth, justice, freedom, love, equality, peace, do ordain and promulgate this Constitution. Nanumpa po tayo na susundin natin tong Constitution na to. Madali pong sumumpa, mahirap to pa rin. Madali pong sumumpa na susundin kung naniniwala tayo sa desisyon. Paano kung hindi tayo naniniwala sa desisyon? Paano kung ang tinatanggal ngayong hapon na to ay si President Marcos at ayaw kong maging presidente si Vice President Sara Duterte? Will I have the courage to follow the same decision? That is the test I apply to myself today. Tinignan ko po ang Supreme Court decision, solid po. Hindi nito inaalis ang kapangyarihan sa House to initiate impeachment. February 6 po, sigurado yan. In fact, before February 6, may quadcom na, magiging glorieta na yan soon. Tuloy-tuloy po yan, yung mga investigasyon na yon, kasi ganun ang politika sa Pilipinas. I hope yung sa baha, imbestigahan din. I hope yung sa corruption, sa smuggling, sa karami-rami nating utang, not only this administration, last administration, 10 administrations. We in this room are all for accountability, but tama yung Supreme Court sa tamang panahon, tamang proseso. Jeremiah 29:11 tells us, "For I know the plans I have for you, plans to prosper you and not to harm you, plans to give you hope and a future." Plano ng Diyos, pagpalain tayo. Pero plano ng Diyos, durugin tayo. So, I remember this episode, I think it was in Twilight Zone, and it was also many, many times portrayed on television. What if nakilala mo si Hitler when he was 6 years old? Or when he was a baby, papatayin mo ba siya? I think even sa psychology or philosophy classes, tinatanong to ng mga professors, what if you had that unique opportunity, nakatabi mo si Hitler nung 6 years old siya, papatayin mo ba siya? Ang hirap sagutin nun. Of course, for us who believe that thou shall not murder, ang sagot madali. But what if you could have prevented the worst human rights violations in the world, the Holocaust? What if you could have prevented such fire of fascism that it actually swept, kung hindi ako nagkakamali, nag-Time Magazine of the Year pa si Hitler. I wonder what our answer is. But I know my answer here today. If you kill Hitler when you are 6 years old, if you justify the ends by the means, you will create more Hitlers. So if the Vice President is guilty, dapat po siya ay i-impeach. Pero sa tamang panahon at tamang proseso. Nagsalita ng Korte Suprema na mali ang proseso, mali ang panahon. But yun po, Mr. President, sana kung ano ang discussion since February 5 dito na nakatuon kay Vice President Sara Duterte, sana kung sino ang guilty sa mga baha, ganun din tayo. Hindi naman siguro si Sara ang gumawa ng mga baha. Sana po kung ano ang cause ng pagkabansot or stunting yung corruption, ganun din, araw-araw talagang wag natin tantanan. Lastly, Mr. President, may I make an appeal to the media, our friends, the vloggers, yung iba nandito, political analysts, advocates, school deans, etc. Nakalagay kasi dito, we all agree on a regime of truth. Parati na lang ang vloggers ang nasasabihan na fake news. Alam nyo po, marami tayong political analyst ngayon, di naman sila analyst eh. Ang ibig sabihin ng analyst provides objective, non-partisan, data-driven explanation of political events, systems, and trends. Ang ibig sabihin naman ng advocate, champions a specific cause, policy, or interest group to influence public opinion and policy decisions in favor of their positions. Wala namang masama dun eh. So kung ikaw ay advocate, sabihin mo na lang. Pero mag-a-appear ka sa TV, magpapa-interview ka, sasabihin mo political analyst. Pero gusto mo lang, bata mo maging presidente, nililito mo pa ang tao eh. Ganon din po, ilan beses kami binugbog dito nung iba, na ang sabi, bawal daw ang isang senator judge na mag-move to dismiss. Pero sila din ngayon ang nagsasabi sa mga senator judge, mag-MR kayo sa Supreme Court. Saan ka kayo nakakita na hindi pwede mag-motion to dismiss? Judges dismisses cases because of no jurisdiction. Ang CA, 3 sila o 5. Hindi nyo lang nakikita sa publiko at hindi sila mag-move kasi sila lang nag-uusap. Ang Supreme Court, hindi ba dinismiss nila? Hindi ba sinabi nila no jurisdiction? Tayo kasi dito nag-usap sa hall na to. So natural, hindi naman pwedeng si Senator Batorni ay tumingin lang sa akin tapos maisip niya, dismiss. Walang manifestation dito na hindi sinasabi. My point, Mr. President, is that yung sinabi ni Mahatma Gandhi nangyayari na sa Pilipinas eh. Sabi ni Mahatma Gandhi, if it's an eye for an eye, the whole world will go blind. Let's make our stand. Ilang beses ko narinig dito sa hall na to, ang taong bayan, ang taong bayan, ang taong bayan. Hindi ba naman lahat naman tayo halal ng taong bayan eh, di ba? Hindi ba pwedeng sabihin ko na lang, ang opinion ni Alang Cayetano, isa lang naman ako eh. Ang opinion ni Joel Villanueva, ang opinion ni Mocha Uson, isa lang naman siya eh. Pero yung sabihin ko sa inyo, guys, ang opinion ng civil society, ang opinion ng masa, ang opinion ng taong bayan, dapat makonvict. Are we not overstepping and are we not confusing rather than enlightening our political processes? Yes, you might think this is a different Alang Cayetano from the impeachment of President Estrada, impeachment of President Arroyo, impeachment of yung hindi natuloy na impeachment kay CJ Davide, sa impeachment ni CJ Corona. But aren't we supposed to be wiser? At hindi ba tama naman yung sinabi ng Supreme Court? Dapat may impeachment pero hindi dapat gamitin ito ng magkalaban lang sa politika. Ayaw natin maging presidente si Vice President Sara, talunin nyo na lang sa 2028. Ngayon, kung talagang may ginawa siyang masama, edi impeach pero sa tamang paraan. I apologize if I'm emotional on this issue, but hindi tayo makawala eh. Ang daming mas importanteng issue, pero nakapako tayo sa issue na to. Thank you, dear colleagues, and thank you to the Filipino people for the opportunity to share my thoughts on this. So I vote for the motion of Senator Marcoleta.
Secretary will proceed.
Senator Cayetano Pia.
I vote yes, Mr. President, and I will explain my vote.
The lady may proceed.
Thank you. Why are we here today? Why do I have to cast my vote? It is because a group of citizens, including the members of the House of Representatives, exercised the right to impeach an impeachable officer. Under the Constitution, there are two ways to file a verified complaint for impeachment. Article 11, Section 3.2 by any member of the House of Representatives or by any citizen, and Article 11, Section 3.4 by one-third of all members of the House of Representatives upon a verified complaint or resolution. There were 4 impeachment complaints filed. December 2, December 4, the third on December 19th, and the 4th complaint was endorsed by 215 members of the House on February 5, the last day. On February 18, 2025, Vice President Sara Duterte filed a case with the Supreme Court to question procedural and substantive due process. Her arguments: the House of Representatives circumvented the constitutional one-year ban rule on initiating impeachment proceedings. I won't go into the details, Mr. President, but I will submit my full speech into the record. Vice President Sara's prayer was for the Supreme Court to issue a TRO as well as a writ of preliminary injunction to enjoin all respondents from proceeding with the impeachment trial. After proper proceedings, issue a final injunction, nullify and set aside the 4th impeachment complaint, declare the one-year bar to be applicable from the filing of the 1st impeachment complaint, declare the 4th impeachment complaint to be violative of the one-year bar under Section 3.5, Article 11 of the Constitution. Sa madaling salita, ang prayer po ni Vice President Duterte ay pigilan ang impeachment proceedings dito sa Senado. In the comments of the HOR, they argued the complaint is not barred for the following reasons. None of the first 3 impeachment complaints were referred to the House Committee on Justice, which effectively ended the initiation process. And 2, Petitioner Duterte is stopped from questioning the freezing of the first 3 impeachment complaints for not immediately assailing it. Ano naman ang sinabi ng Supreme Court? The Supreme Court said the Articles of Impeachment transmitted by the HOR to the Senate based on the 4th impeachment complaint is barred by the one-year rule under Article 11, Section 3.5. It is also constitutionally infirm and therefore null and void ab initio. Ang ibig pong sabihin, hindi na dapat ituloy pa ang impeachment proceeding na ito dahil ang impeachment complaint na isinumite ay labag sa one-year bar rule na nakasaad sa Constitution. Ang probisyong ito ay naglalagay ng limitasyon na isang impeachment complaint lamang ang maaaring maisulong sa loob ng 1 taon. Dahil sa paglabag na ito, ang impeachment complaint na ito ay itinuturing na labag sa konstitusyon at walang bisa mula sa simula o tinatawag na null and void ab initio. Mahaba po yung diskusyon ng Supreme Court dyan, makikita ho yan dun sa kaso, dun na lang ho sa isusumite ko, mababasa po doon yung ine-emphasize ko na provisions. So in final, sabi ng Supreme Court, the Senate did not acquire jurisdiction to constitute itself as an impeachment court. And this decision is immediately executory. Ano ho ba ang ibig sabihin ng immediately executory? Ibig sabihin po nito na notwithstanding the filing of a motion for reconsideration by the House, the Supreme Court's decision is immediately executory, such that the MR will not stay the decision. Katulad po ng sinabi ko kanina, dun sa press briefing ng Supreme Court, after mag-file ng motion for reconsideration ang House of Representatives, inulit pa rin ng Supreme Court na immediately executory po ito. Ano ba talaga ang karapatan ng Supreme Court na makialam dito sa impeachment case na ito? Well, ito po yung tinatawag na judicial powers ng Supreme Court. The Constitution expressly grants judicial power to our Supreme Court. Article 8, Section 1 of the Constitution provides that judicial power includes the determination of whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of government. Sinabi po dito, any branch, kasama po dyan ang Senado. Pwedeng sabihin ng Supreme Court na may grave abuse ang Senado. Pwedeng sabihin yon. Pwede niya ring sabihin sa House yon. Pwede niyang sabihin sa kahit anong branch of government. Yan po ang nakasulat sa ating Constitution. In Francisco versus House of Representatives, the Supreme Court ruled that, and the judiciary in turn, with the Supreme Court as the final arbiter, effectively checks the other departments in the exercise of its power to determine the law, and hence to declare executive and legislative acts void if violative of the Constitution. So sinabi talaga dito, possible na ang Executive Act, ang Legislative Act ay maging void. In case of conflict, the Judicial Department is the only constitutional organ which can be called upon to determine the proper allocation of powers between the several departments and among the integral or constituent units thereof. The House of Representatives urged the Supreme Court to exercise judicial restraint. Sabi ng House, hinay-hinay lang, Supreme Court, so that you can avoid encroaching upon the powers of the legislature and violating the principle of separation of powers. However, the Supreme Court in Duterte versus HREP held that there is a clear and demonstrable textual commitment in the Constitution for the court to act on any grave abuse of discretion of any branch or instrumentality of government. This includes the House of Representatives or the Senate in their exercise of their prerogatives with respect to the process of impeachment. Grave abuse of discretion from the provision does not mean actions without jurisdiction. It includes acts which originally may have been within their discretion, but subsequently the subject of a violation of a constitutional right. This is what is meant by excess of jurisdiction. This court does not decide whether and when to initiate a case of impeachment. However, the court has the power to decide how the provisions which limit the exercise are to be interpreted. On due process, numerous Supreme Court decisions expound on procedural due process in various contexts. These cases underscore the Supreme Court's enduring commitment to uphold procedural due process as a safeguard against arbitrary government action. Bakit po pumasok itong issue na due process? Kasi sinabi ng Supreme Court, hindi naman nagkaroon ng pagkakataon ang Vice President na makita ang complaint sa kanya, hindi rin nakita ang mga ebidensya. Due process exists kahit saan daw pong parte ng paggogobyerno natin. Based on the decision, in order to proceed with the impeachment proceedings, the House prosecutors must show not only a valid ground thereof, but also that procedural due process has properly been observed. As this safeguards individuals from the arbitrary exercise of government power by requiring adherence to fair procedures. As such, when there is a violation of due process as enshrined under the Constitution, the case must be dismissed. Kailangan ba ng Senado sumunod sa Korte Suprema? Sinabi ko po at uulitin ko na ang sabi ng Korte Suprema, void ab initio nga po ang kaso. Walang bisa. In Latin, void ab initio means void from the beginning. Sa umpisa pa lang, void. It indicates that something was never valid or legally effective from its inception, rather than becoming invalid at a later point in time. So sa umpisa pa lang, invalid. Hindi siya naging invalid later on, invalid siya sa umpisa pa lang. Absolutely non-existence from the very beginning. Yan ang ibig sabihin ng ab initio. Null and void. It produces no rights, imposes no duties, and affords no protection. It has no legal effect. It is, in legal contemplation, inoperative, as if it has not been passed. As such, it cannot justify an official act taken under it. Yun po ang basihan ng aking desisyon. It cannot justify an official act taken under it. Hindi ho pwede nating pasukin. Gustuhin man natin alamin. Kapareho ho ako ng napakaraming kababayan natin na gusto nating alamin kung ano ba ang mga issue na to. Pero sabi ng Supreme Court, hindi ho natin pwedeng gawin yon. We have to follow the rules. At idadagdag ko, nang sinabi nga ng Supreme Court, ay ito ay immediately executory. Again, the decision stated the Senate did not acquire jurisdiction to convene itself as an impeachment court. As such, there is no constitutional authority to even convene as an impeachment court. I am a member of the Senate and I am a lawyer. I am bound by my solemn oath. Nag-oath po tayo last week lang. Ang sabi dun sa oath, I will well and faithfully discharge to the best of my ability the duties of my position. Ginusto ko ba to? Do I want to be a judge here? Hindi po. Nung nag-aral po ako ng law, sabi ko, Lord, wag niyo akong gawing judge. I hate being a judge. Malambot po ang puso ko. Kung pwede, lahat innocent. Yun ho ang gagawin ko. Kasi napakahirap humusga ng ibang tao. But this is my solemn duty. It is my duty. I took an oath. And therefore, gustuhin ko man o hindi, I have to make a decision. And binabase ko ang aking desisyon kung ano ang sinabi ng Supreme Court. Yun naman po aming lawyer's oath. I do solemnly swear that I accept the honor, the privilege, duty, and responsibility of practicing law in the Philippines as an officer of the court in the interest of our people. I declare fealty to the Constitution of the Republic of the Philippines. Idudugtong ko yung oath na yon dun sa sinabi ng Supreme Court na kailangan sundin ang Constitution. At siya ho ang magpapaliwanag kung paano i-interpret ang Constitution. My duty as a senator and as a lawyer is to be guided by evidence, by the rule of law, and by the principles enshrined in our Constitution. For these reasons, Mr. President, I cast my vote as yes. Thank you.
Thank you, Senator Pia Cayetano. Secretary.
Senator De La Rosa.
Senator Ronald Bato de la Rosa is recognized.
Mr. President, I vote yes to the motion of Senator Marcolita, and may I be allowed to explain my vote? Thank you, Mr. President. Last June 10, a day before the 19th Congress adjourned sine die, I stood on the same spot conveying my serious concerns on the constitutional infirmities surrounding the Articles of Impeachment that the 19th Congress of the House of Representatives transmitted to the Senate. I pointed out that the circumstances surrounding the filing of Articles of Impeachment seem to violate the one-year bar rule enshrined in Article 11, Section 3, Paragraph 5 of the Constitution, among others. Given this patent violation of the Constitution, I made a motion to dismiss the Articles of Impeachment against Vice President Sara Duterte. After a long discussion with the members of this chamber of the 19th Congress, I listened and I learned my motion for dismissal was amended by Senator Alan Cayetano and became a motion to remand. The impeachment court then ordered the remanding of the Articles of Impeachment to the House of Representatives. This chamber also requires the 20th Congress, House of Representatives, to communicate whether or not they are willing and ready to pursue the impeachment complaint, a requirement which until now has not been complied with. In a sudden shift of events, before the opening of the 28th Congress, the Supreme Court took all by surprise when it promulgated their decision on petitions challenging the validity of the Articles of Impeachment against Vice President Duterte. When the Supreme Court released their decision to the media, many people expressed their views. There are those who celebrated and commended the Supreme Court. Others voiced out their disappointments. Some criticized the decision. The mixed reactions seem to suggest that the decision promulgated lacks clarity. And yet, Mr. President, after reading the decision, I asked myself, is it long? Yes, 97 pages to be exact. Is it vague? No, Mr. President, it is clear as day. According to the plain meaning rule or verbal leges, if the statute is clear, plain and free from ambiguity, it must be given its literal meaning and applied without interpretation. Now, even though the decision of the Supreme Court is not a statute, it still forms part of the legal system of the Philippines as mandated by Article 8 of the Civil Code of the Philippines. Since the decision of the Supreme Court is clear, plain and free from ambiguity, applying the plain meaning rule, it should be given its literal meaning. That is, the Articles of Impeachment are unconstitutional the Senate did not acquire jurisdiction and the decision is immediately executory. Plain and simple. Kaya naman, Ginoong Pangulo, nagulat ako nung ako'y tanungin, susunod po ba ako or tayo sa desisyon ng Supreme Court? Hindi po ganon kataas ang tingin ko sa aking sarili. I honestly do not place myself in a position so high, too high, that I will be the one to be asked if I will obey the Supreme Court's ruling. Ang nakasaad sa ruling na yon, immediately executory. Wala namang postscript or PS sa baba na nagsasabing subject to your review and further evaluation. As a member of the Senate and as a citizen of this republic, I submit to the authority of the Supreme Court and respect its decision. Perhaps in shedding light on the highest court's duty, the integrated bar of the Philippines said it best, and I quote, "As the final arbiter of constitutional questions, the Supreme Court bears the solemn duty to interpret the law, determine its bounds, and clarify its implications, even when it revisits past doctrines or addresses new contexts. This authority is rooted in checks and balances, the very design that guards against the excesses of any branch. Mr. President, the rule of law is the foundation of our democracy. And if we are to be models of upholding the law, then it behoves us to listen and heed those who have been tasked by the Constitution to interpret the Constitution. The interpretation of the law remains lodged with the Supreme Court, and we must abide by its decision. What message would we send out to our people if we, legislators, will not honor the wisdom of the highest court in the land? Are we not, in effect, promoting anarchy? I want to believe that indeed we are men and women of the law, that we live by rules and perform our mandate as elected officials within lawful means. Our people rest easy and feel a sense of security because their Senate has remained to be guardians of democracy. Looking back, the Senate has accepted several Supreme Court decisions in the past. Why should the ruling in this current impeachment case be any different? Is our concept of respect for and acceptance of Supreme Court decisions selective? If that is the case, are we not playing with fire? Fire, mind you, does not always intend to enlighten or illuminate. It can also burn and bring a house down. Much has been said about where I stand, and I understand that my positions on certain matters have always been consistent and transparent. But while the public and this chamber may be familiar with my views, all that is simply driven by what is in my heart. And I say this with humility. My heart has always been guided by what is right, not only when it is easy, not only when it is convenient, but even and especially when it challenges my comfort zone, when it no longer serves our side. Because at the end of the day, it is a matter of principle, not popularity. Perhaps sometimes we ought to protect our democracy, even from ourselves. Of course, the Senate is not a mere follower of the Supreme Court, but a co-equal branch, meant to respect the powers and functions of the latter in its decisions. I trust that the Senate will continue to peacefully coexist with the Supreme Court. Let us not allow this impeachment trial to become a venue and opportunity to disrupt our system of government. I hope this is not the time when we dance differently, when clearly the same song is playing. We must follow the Supreme Court ruling, not because it is the most convenient thing to do, but because it is what is right and just, no matter how unacceptable or painful it may be. And this is why, Mr. President, I vote yes to adhering to the Supreme Court decision. Thank you, Mr. President.
Thank you, Senator De La Rosa. Mr. Secretary.
Senator Ejercito.
Senator Ejercito is recognized.
Yes, Mr. President, I likewise vote yes to adhere to the Supreme Court.
Thank you, Senator Ejercito. Secretary.
Senator Estrada.
Senate President.
Senate President Escudero.
The Senate President is recognized to explain his vote.
Thank you, Mr. President. Distinguished colleagues, sa mga minamahal nating kababayan. For many of us, the past 2 weeks have proven to be an exasperating, mentally and emotionally exhausting experience. Both sides have fought bitterly a dialectical struggle to articulate what they respectively believe to be the correct position or view on the issues involved. Passions had run high as demonstrators, whether for or against impeachment, took to the streets armed with their familiar slogans and chants to air their voice on the matter. Various sectors of society, from business, retired military, academe, denominations of faith, offered suggestions for a return to a state of normalcy in the official relations of governmental branches. Through all these, and as early as the time when the Articles of Impeachment had been constituted, the court was specifically asked, told, urged, and argued to take no action of any kind and form with respect to the prosecution by the House of Representatives of the impeachment complaint. When the present petitions were knocking, so to speak, at the doorsteps of the court, the same clamor for non-interference was made through what are now arguments of lack of jurisdiction, non-justiciability, and judicial self-restraint, aimed at halting the court from any move that may have a bearing on the impeachment proceedings. The court did not heed the call to adopt a hands-off stance as far as the question of constitutionality of initiating the impeachment complaint is concerned. What lies in here, is an issue of genuine constitutional material which only the court can properly and competently address and adjudicate in accordance with clear-cut allocation of powers under our system. The claim, therefore, that the court, by judicially entangling itself with the process of impeachment, has effectively set up a regime of judicial supremacy is patently without basis in fact and in law, because it is not at all the business of the court to assert dominance, judicial dominance, over the other two great branches of government. Rather, the raison d'etre of the judiciary is to complement the discharge by the executive and legislative of their own powers to bring about ultimately the beneficent effects of having founded and ordered our society upon the rule of law. Mr. President, distinguished colleagues, the institution that is the Supreme Court, together with all other courts, has long held and been entrusted with the judicial power to resolve conflicting legal rights regardless of the personalities involved in their suits or actions. The court has dispensed justice over the course of time, unaffected by whomsoever stood to benefit or suffer therefrom, unafraid by whatever imputations or speculations could be made to it, so long as it rendered judgment according to the law and the facts. No one is above the law or the Constitution. This is a basic precept in any legal system which recognizes equality of all men before the law as essential to the law's moral authority and that of its agents to secure respect for and obedience to its commands. Perhaps there is no other government branch or instrumentality that is most zealous in protecting that principle of legal equality other than the Supreme Court, which has discerned in its meaning and ramifications through its application of numerous cases, especially the high-profile kind in the annals of jurisprudence. The Filipino nation and its democratic institutions have no doubt been put to a test once again by this impeachment case. Accordingly, the court resorted to no other than the Constitution in search for a solution to what many feared would ripen to a crisis in government. Sa muli, magandang gabi po sa ating lahat. Hindi ko po salita mga sinambit ko na ilang minuto. Yun po ay paraphrase at halos eksaktong quotation ng salita ni dating Justice Conchita Carpio Morales sa Francisco ruling na kinatigan ng mayoriya ng mga miyembro ng Korte Suprema, kabilang na si dating Chief Justice Puno, dating Justice Carpio, dating Justice Ascuna, dating Justice Panganiban. Ano nga ba itong Francisco ruling na pinag-uusapan natin to? Ano nga ba ang pinagkapareho, pinagkaiba nito sa kasalukuyan nating hinaharap? At bakit ko ba ito tinatanong? Ginoong Pangulo, bahagi ako ng Kongresong nagtangka na i-impeach si dating Chief Justice Davide. Bakit ko sinabing tangka? Dahil pinigilan po kami ng Korte Suprema. In-enjoin at nag-issue ng TRO ang Korte Suprema at ito yung desisyong yun. Francisco, case na palaging sinasite po natin. Ano bang pinagkapareho? Ang aligasyon laban sa nasasakdal noon na si Chief Justice Davide, kaugnay din ng corruption. Daang milyon din. Ang pinag-usapan, initiation of impeachment, na dapat sole prerogative din ng Kamara. Ang pinag-usapan, ano bang definisyon ng initiation na dapat sole jurisdiction din ng Kamara? Ang tanong ko po ay simple. Noong mga panahong yun, nasaan po lahat na nagrereklamo ngayon at nagko-question sa desisyon ng Korte Suprema? Yung mga mahistradong nagko-question ngayon na retirado na, bumoto sila pabor doon. Subalit ngayon, tila nag-iba ang posisyon. Ano nga ba ang pinagkaiba kung meron man? Klaro ang pinagkaiba. Iba ang pangalan ng nasasakdal. Today, Mr. President, distinguished colleagues, the very supremacy of the Supreme Court is being called into question, and with it, the very foundation of the rule of law. As Senate President and as a member of this chamber and as a member of the bar, I will not sit idly by and allow this. At stake is the very idea that justice should be governed by laws that apply to all, equally to all, rather than the whims and caprices of public opinion. As Justice Frankfurter once said, if one man can be allowed to determine for himself what is law, every man can. That means first chaos, then tyranny. Legal process is an essential part of democratic process. Whether it's a mob or a minority, bias and prejudice blinds, divides, and destroys. Former U.S. Supreme Court Justice Sandra Day O'Connor also said it best. The law provides necessary continuity amidst our constantly shifting political landscape. It guarantees everyone will be treated equally, whether they are in today's or yesterday's majority, so they know what to expect, whether what they do is popular or unpopular at that time. The courts, Mr. President, with the Supreme Court at the helm, are the guardians of the rule of law, making sure everyone plays by the same rules and receives equal justice. For the rule of law to prevail, the High Court must act as a compass, not as a political cheerleader, impartially applying the law by calling out violations, not swayed by public opinion or political allegiance. Respect for the rule of law, Mr. President, requires all of us to adhere to final or immediately executory decisions of the court, even when there is a winner and a loser, to avoid deadlocks and maintain legal order. Respect for the rule of law does not bar disagreeing with court decisions, nor from forming our own opinions on the meaning and intent and letter of the spirit of the Constitution. However, we must also have the humility to accept when we are wrong once the Supreme Court has already decided. Respecting the court only when you win or when it aligns with your belief is not respect for me. It is plain arrogance, or if at all, a power play. Cherry-picking court rulings destroys the judiciary's purpose. Disobeying the High Court's decision is a violation of the law, because under our Constitution, decisions of the Supreme Court form part of the law of the land. I made these remarks, Mr. President, amidst recent calls for this august body to disregard the Supreme Court's recent ruling in Duterte v. HOR. These calls for judicial disobedience have been aided and abetted by so-called legal luminaries and experts who fancy their wisdom and knowledge of the Constitution as better, higher, more supreme than that of the Supreme Court. Miyembro po ba sila ng Supremist Court? Miyembro po ba sila ng Super Supreme Court? Sa pagkakaalam ko po, iisa lamang ang Korte Suprema. At ayon sa ating konstitusyon, Korte Suprema ang bukod tanging pwedeng makapagsabi kung ano ang kahulugan ng ating saligang batas. Walang iba. Allow me to demonstrate, for example, Mr. President, the legal gymnastics these people have been undertaking. In the past, and I have borne the brunt of this, sabi nila, forthwith ang sinabi sa Senado, ibig sabihin yan agad-agad. Despite the rulings of the Supreme Court that say it is within a reasonable time. Pero doon na tayo sa agad-agad. Sabi ng rules ng House, dapat i-refer ng SecGen immediately sa Speaker. 2 buwan bago niya ginawa yon. Oh, okay lang sa kanila. Hindi naman sila nagreklamo. Immediately po ang gamit hindi forthwith. Sabi naman ngayon ng Korte Suprema, immediately executory. Ay, teka lang. Hintayin muna natin. Hindi ba final? Kapag ka-convenienteng gamitin yung mga salita pabor sa posisyon nila, edi okay lang. Kapag ka hindi naman, ay hindi rin. Hindi po ganun dapat yon. Hinihiling nila ngayon sa Senado na ipagpaliban muna ang anumang aksyon para intayin ang anumang desisyon ito kaugnay sa motion for reconsideration na inihain ng Kamara sa Korte Suprema. Subalit tulad ng naipaliwanag na kanina kaugnay ng motion na pinagbobotohan natin ngayon, kung magbago man ang Korte Suprema sa kanilang desisyon na unanimous noong July 25, 2025, meron pong paraan at proseso pa ang Senado para sundin ang bagong desisyon yan ng Korte Suprema kung sakasakaling mangyayari po yan. In the past, it was also said, nauna nagsalita si Senator Bato, bawal daw at walang karapatan mag-motion ang sinumang Senator Judge dahil trabaho daw ng depensa yon. Bakit yung mga parehong tao yung pinag-uusapan? Dapat maghain tayo ng motion for reconsideration. Hindi ba trabaho din ng prosecution yon? Hindi naman po pwede na pwede lang pag kayo, hindi na pwede pag iba. Now the prosecution has actually filed a motion for reconsideration, and rightfully so, and not by this chamber. Noon nung bumoto kami para i-remand ang impeachment complaint sa Kamara, pinapaboran daw namin yung nasasakdal. Sinabi ko na rin yan, na yung kontra sa impeachment at pabor sa impeachment, hindi ko didinggin. Na yung kontra at pabor kay Vice President Sara Duterte, hindi ko didinggin. Dahil may rason kung bakit babaeng nakapiring ang mata ang simbolo ng ating hustisya, na humahawak ng espada sa kabilang kamay at panimbang sa kabilang kamay. Dahil wala po dapat kinikilala ang hustisya na personalidad. Sino man ang nasasakdal, dapat pareho lamang po ang ating mga magiging desisyon. Sabi din nila, will of the people daw ito. Sino ba si people? Balikan po natin ang naging desisyon ng Korte Suprema. Ayon sa desisyon ng Korte Suprema sa panunulat ni Justice Malcolm sa Alejandrino versus Manuel Quezon, pinag-aaralan po ito ng mga first-year law students. Quote, the judiciary under its powers to interpret the Constitution and the laws has the duty and the right to declare what the will of the people is as expressed in the fundamental law of the land. Hence, where the acts of the executive or legislative departments violate the will of the people as expressed in the organic law of the land, it is the sworn duty of the judiciary to interpret and to declare that will of the people and the right of the citizen has been violated and or transgressed. Allow me to answer a few more, Mr. President, Your Honor. As I stated earlier, sabi ng ilan, hintayin natin na maresolbahan ang motion for reconsideration. Pero dun sa parehong araw na naghain ng motion for reconsideration ng Kamara, nagsalita ang tagapagsalita ng Korte Suprema at sinabing immediately executory pa rin ang desisyon. Sinahit ko rin kanina ang Section 1, Rule 16, AM number 10-4-20 ng Supreme Court na nagsasabi na ang resolusyon ay magiging executory lamang kapag ka ito'y nagkaroon ng entry of judgment maliban na lang kung